All good to go, Hansard and Broadcasting? Great, thanks very much. I declare open this hearing of the Senate Rural and Regional Affairs and Transport Legislation Committee into Aviation Consumer Protection Bill 2026 and three related bills. And I begin by acknowledging the traditional custodians of the land on which we meet today, and I pay my respects to those past, present and emerging elders, and I extend respect to Aboriginal and Torres Strait Islander peoples here today. For the benefit of witnesses, I am the Chair, Senator Glenn Sterle. I am joined today by Deputy Chair Senator Ross Cadell and long-standing Senator Colbeck and Senator DeLiga. Senator Mulholland will be joining us remotely. Welcome everyone. The committee will be conducting today's hearing via video conference and in person. These are public proceedings being video streamed live via the Parliament's website, and a Hansard transcript is being made. I remind all witnesses in giving evidence to the committee they are protected by parliamentary privilege. It is unlawful for anyone to threaten or disadvantage a witness on account of evidence given to a committee, and such action may be treated by the Senate as a contempt. It is also a contempt to give false or misleading evidence. Witnesses also have a right to request to be heard in camera. If a witness objects to answering a question, they should state the ground upon which the objection is made, and the committee will determine whether it will insist on an answer having regard to the ground which is claimed. Excuse me. If the committee determines to insist on an answer, a witness may request that the answer be given in camera. I remind senators of their obligations under the Behaviour Code for Australian parliamentarians to treat witnesses with dignity, courtesy, fairness and respect. Finally, I remind witnesses and any committee members who are appearing via video conference and who are not speaking to please mute your microphones and remember to unmute when you are called upon. I now welcome our first panel, all joining us by video conference, including representatives from the Australian Lawyers Alliance, the Law Council of Australia and the Australian Human Rights Commission. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. I remind senators that in relation to the AHRC, the Senate has resolved that an officer of a department of the Commonwealth or of a state shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. This resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. Now, for the Hansard record, would you please state your full names and the capacity in which you appear today? And I'll probably work my way from my left to our right on the table in front of us. Ms Holt.
Thank you. My name is Rachel Holt. I'm the Senior Executive of the Investigation and Conciliation Service at the Human Rights Commission.
Thank you. And we then have Ms Caius, is it? I'm sorry, I haven't got my glasses on. You're on mute? Sounds like the Tic Tac or the Kit Kat commercial, doesn't it?
Yep.
I'm on.
Yep.
I'm Rosemary Kays. I'm the Disability Discrimination Commissioner.
Thank you very much. And is it Miss Roy? That's all blurry.
Yeah, it is.
Miss Roy, are you there, Miss Roy?
Sorry. Yes, I was just unmuting my microphone. Sorry. Yes, I am Victoria Roy and I am Chair of the Travel Law Special Interest Group of the Australian Lawyers Alliance.
Thank you very much. Now, I'm going to invite each organisation to make a short opening... Oh, I'm sorry. There's a Miss Webster. A Miss Webb? Oh, sorry, Miss Webb.
That's all right. Yes, I'm Kirsten Webb and I'm representing the Law Council of Australia.
I apologise. Thank you, Ms Webb. Now, I will invite each organisation to make a short opening statement, and at the conclusion of any remarks, I'll invite members of the committee to ask questions. So, Ms Holt, would you like to go first?
Actually, it's the Disability Commissioner who will be making a statement on behalf of the Human Rights Commission.
Fantastic.
Ms Cayes.
Ms Cayes, you are mute. We can't hear you.
No, yep.
I haven't started speaking. That might be a little bit...
Oh, right, gotcha.
Might play a part in it.
Okay.
So first of all, I'd like to start by acknowledging the Gadigal people of the Eora Nation, the traditional owners and custodians of the country on which I am speaking to you from today. I pay my respects to their elders, past and present and emerging, who have provided continuous care to the land, sea and waterways for thousands of years. I extend this respect and acknowledgement to any First Nations people joining us today. First of all, I'd like to thank you for the opportunity to appear before you today in my role as Disability Discrimination Commissioner at the Australian Human Rights Commission. I am accompanied by my colleague Rachel Holt, Senior Executive for the Commission's Investigation and Conciliation Services. Air travel should be a dignified experience for all people. In a country as vast as Australia, air travel is critical to enable people to maintain family ties, participate as active members of the community, enjoy leisure and recreation, and to access employment opportunities and health services. People with disability experience significantly more barriers accessing air travel on an equal basis with others and are generally less satisfied with their experience of air travel. Ableism results in discrimination and it remains common. Addressing service issues and reducing barriers in air travel is an important step towards facilitating the rights of all people. The Aviation Consumer Protections Framework will provide clear service standards and consumer rights for all people who use air travel. As outlined in the Commission's submission, this should be guided by human rights principles. While the Commission is supportive of the framework being established, there are some unresolved factors in Aviation Consumer Protection Bill 2026. The most significant which is the duplication and overlap in complaints jurisdiction between the Aviation Consumer Ombud Scheme and the Commission where it relates to accessibility and discrimination. The Commission has a long-standing complaints jurisdiction and expertise under federal discrimination law, including in relation to aviation services. The Commission's statutory functions and powers uniquely position us to deal with complaints about discrimination in the delivery of goods and services. The bill creates a risk that the same complaint could be pursued in multiple jurisdictions, either simultaneously or sequentially following an unsatisfactory outcome. This unnecessary duplication will create ineffectiveness, inefficiencies, and confusion for consumers, regulators, and industry, as well as increase the burden on respondents and delays in resolving complaints. It is also unclear how potential overlap and regulatory complexity will be addressed between the Aviation Consumer Protections Charter and the proposed aviation disability standards under the Disability Discrimination Act. Given the concurrent development of these reforms, rules or guidelines alone are not an appropriate way to resolve this issue. Rather, the bill could address this by clearly designating the Aviation Ombud Scheme main jurisdiction and explicitly addressed how the proposed aviation dispute resolution scheme will operate alongside existing anti-discrimination complaint mechanisms, and providing a mechanism to prevent complaints being pursued in multiple jurisdictions at the same time or after an unsatisfactory outcome. Consideration must also be given to the limitation on complaints bodies, such as the Commission, to disclose certain information that may have an impact on referral processes. There are other elements of the bill and framework that should be addressed to ensure it adequately protects human rights. The bill should introduce a legislative requirement to provide procedural accommodations in the operational requirements of the Aviation Consumer Ombud scheme to ensure access to justice on an equal basis with others. And the bill should allow the Ombud to prioritise and rapidly resolve urgent complaints where a delay in resolving the complaint would restrict human rights. The Commission remains committed to working constructively with the government on the issues raised. We welcome any questions from the committee regarding these issues and other matters raised in our submission. Thank you.
Thank you very much, Ms Kayes. So I will take now 2 questions.
No other opening statement.
Does anyone else want to make an opening statement? I thought you said Ms Kayes was going to do it.
On those 2.
No one else wishes to make an opening statement?
I have an opening statement from the Australian Lawyers Alliance, please, Chair.
Oh, sure. Go ahead.
Thank you. Thank you, Chair. And I'd also like to thank all members of the committee for inviting the Australian Lawyers Alliance, the ALA, to appear at today's public hearing regarding the Aviation Consumer Protection Bill 2026 and the related bills. For background, the ALA is a not-for-profit association, and I, Victoria Roy, volunteer as chair of the ALA's Travel Law Special Interest Group. In my private practice, I specialise in international personal injury law. I would like first to acknowledge the traditional owners of the lands on which this public hearing is taking place and the traditional owners of the lands from which I appear today. I pay my respects to elders past and present and to any Aboriginal and Torres Strait Islander peoples participating in or observing today's hearing. The ALA is a national association of lawyers, academics and other professionals dedicated to protecting and promoting access to justice and equality before the law. We are represented in every state and territory, and our members represent up to 200,000 people each year across Australia. The ALA has been advocating for improved air passenger rights since the COVID-19 pandemic. We have been an active stakeholder in the various consultations on proposed air passenger rights reform since the announcement of the federal government's aviation white paper, including the primary legislation, which we are discussing today, and the subordinate legislation, which is where the Charter standards will be found. In terms of the legislation that is subject of this inquiry, the ALA broadly supports the direction of the package. For too long, Australian air passengers have not had a simple, affordable and accessible way to enforce the limited consumer rights they have. The ALA therefore welcomes the bill's creation of the Aviation Consumer Ombudsperson, which will make binding decisions in air passenger consumer disputes. However, we have 2 main concerns with this bill package. Firstly, Section 9 of the bill permits exemptions from the new rights framework, and we object to that exemption generally and the government's indication that it intends to exempt airports with fewer than 1 million passengers per year. The ALA opposes this exemption as it will disproportionately impact regional Australians who are reliant on aviation for essential travel, including access to specialist medical treatment. It also creates a 2-tier system of rights and complexity for passengers, when frankly there is enough complexity in this space already. The ALA's second key concern is that this bill does not give the new ombudsperson the clear and unambiguous power to make airlines compensate passengers for unreasonable delay that is within their control. The bill package is a missed opportunity to clarify and standardise air passengers' Australian consumer law rights to flight delay compensation and provide the same consumer certainty as occurs in countless jurisdictions like Canada and the EU, amongst others, whose rules are already binding on Australian airlines who operate there. I could elaborate, but I'm conscious of the time I have for this opening statement, but I thank the committee for the opportunity for the ALA to appear, and I'm also more than happy to answer questions.
Well, thank you, Ms Roy. Ms Webb, would you like to make an opening statement?
Yes, I will. I'll be brief, Chair. The Law Council of Australia welcomes this opportunity to appear before the committee this morning as part of your review. We're conscious that this is a review that relates to the 4 separate bills, but our primary focus has been on the Aviation Consumer Protection Bill. If the committee has any questions relating to the other 3 bills, we'll happily take those on notice. Turning to the Consumer Protection Bill, we support the objective of ensuring a safe, competitive and sustainable aviation sector that delivers fair outcomes for consumers. The feedback that the Law Council has provided and the recommendations that we've included in our written submission really go to promoting clarity and certainty within the proposed regulatory framework. One key issue that we've raised is the bill's delegation of substantive consumer protections to delegated legislation. The bill establishes only a high-level statutory framework and doesn't itself prescribe substantive consumer rights and obligations. Instead, the minister is empowered to make the Aviation Consumer Protection Charter and to determine additional requirements in the form of standards, both of which are legislative instruments. Our recommendation is that core consumer entitlements and minimum standards should be specified in the primary legislation, where they're subject to parliamentary scrutiny and open to stakeholder engagement and public debate. The bill establishes multiple institutional actors with overlapping responsibilities, alongside existing regulators with concurrent jurisdiction. We see that is very likely to create consumers, both for consumers and for regulated entities. And we've recommended that at minimum, consolidated guidance on consumer entitlements and complaint pathways be published once the charter and standard are in force. We've also drawn attention to the civil penalty framework set out in the bill, which imposes significant civil penalties for breaches of charter requirements and standards, but the content of the charter requirements and standards has not yet been determined. The rule of law generally requires that obligations be defined with sufficient clarity and certainty before enforcement action may properly be taken, and we've recommended that the charter and standard be finalised and subject to public consultation before civil penalty provisions come into force. We've identified some gaps in the scope of the framework that have been touched on in the other opening statements and are set out in our submission, and in relation to accessibility and also to children's rights. While the bill identifies accessibility and children's rights as statutory objectives, there's no guarantee that the charter or standard will address them, and we recommend that these be mandatory requirements under the standard. All of this is set out and more in our written submissions for the benefit of the committee. We thank you for the opportunity to appear and look forward to responding to any questions you might have.
Thank you, Ms Webb, and I'm conscious of the time too, so I'll flick straight across to Senator Cadell.
Thank you, Chair. Thank you all for your evidence. I think comes across where I think we're all supportive of the objectives. I think that comes across quite thin, but personally, from a read, I'm finding this a legislatively lazy way of doing things. I think we raise the fact that the charters aren't disclosed and the different layers of potential actions, but there are limited redress actions too. I don't think there's any private rights of action and no clear way. I mean, they're also not binding on complainants, and we can go jurisdictional shopping, as you said, from the Australian Human Rights Commission. What do we need from a point of view to make this more robust in both giving private rights and rights of appeal and preventing jurisdictional shopping? I'll take anyone. No one?
Please jump in if anyone wants
Ms Webb, we'll go to you first.
Okay. Well, as the representative of the Law Council, I would say the answer to that question, Senator, is properly and specifically drafted legislation that clearly identifies what the redress rights are and clearly delineates the appropriate paths to pursue those rights to avoid the forum shopping issue that you've rightly raised.
Okay.
Sorry, it's Rachel here. If I could also just echo that point. The Commission is accustomed to handling complaints that an individual may make under our jurisdiction as well as other jurisdictions. And in some instances, there are embedded in the legislation itself statutory bars to prevent a person from forum shopping, so going to multiple different processes. That's one option. The Fair Work Act has another, bar, which means that people can't have actions on foot at the same time, but after one action is finished, they do have the option to make another. I think our concern is that there is a lack of clarity in the proposed bill itself about the different particular areas of responsibility. There will be necessarily some overlap, but we would be looking for greater clarity in the legislation itself, in particular about where the Ombudsman has powers in relation to the Charter and the standards that may very likely overlap with the Commission's jurisdiction in terms of complaint handling. Acknowledging, of course, that the complaints that we handle are necessarily a very small subset of the overall consumer complaints that airlines will be receiving. But nonetheless, they are important complaints, and our experience is clarity at the beginning will really assist the consumers and also the regulators.
I'm having trouble, I'm not a law scholar or anything like this, but I'm having trouble seeing a significant change in what is being offered for a more complex and regulated process, and probably more expensive process for a lot of participants. What's for me is there seems to be a lack of, you all mentioned, I think, Section 9 and the exclusions, but it seems it's inconsistent rights on which airport, how you're paid, the booking method, all these sorts of things. It doesn't seem very clear. There seems to be a no wrong path required, or say, like, what are your views on that? And I might go Ms. Roy first, or it just seems complicated.
I agree, Senator, that it's complicated, and the Australian Lawyers Alliance focus has been on the Australian consumer law issues, and I would have to defer to my colleagues on this panel for the specific issues regarding accessibility. But in terms of the more general consumer complaints, the only other option that consumers have at the moment is essentially to go to court, because the airline consumer advocate has, as I think has been identified, has not been sufficiently helping consumers. So the only option has been to go to court, and so an ombudsperson of this type is at least an improvement on that, because for the everyday consumer, going to law court is too complicated, too scary, too expensive. So at least this is another avenue, but I do appreciate that it is a complicated one.
Ms. Webb, do you have a view on that?
I was going to express a view on the scope for differential treatment of different entities and how to deal with that. I do think, as a general principle, legislative obligations should apply consistently across, in this case, the relevant airports, and making exemptions, or a legislative scheme that starts up front with exemptions that therefore results in a sort of two-tier or more than two-tier framework, I think is problematic at the outset. I think that the legislation should set the primary obligations that apply to all airports in this instance, rather than have an upfront exemption which results in uneven application of the regime and the possible outcomes for regional consumers that have been mentioned by others.
I'll go Mrs. Holt, next one. A massive red flag for us is the lack of the charter being included in the legislation. We're looking at, 2/3 of the picture, and I've always gone back data plus context equals information. We don't have the context without the charters in there. And I'll go generally across the board in any order again, but starting with Ms. Holt's first chance. We look at this as a framework, but the real meat comes on what, and I think it's a flawed framework. The real meat comes in what it's going to be enforcing and what those things are. Where you're talking about the people you look after and in the human rights stuff, how do we know that this is fit for purpose when we don't know what the rules to be enforced are?
That's one of the issues that the Commission has raised in its submissions, that the proposal, I think Ms. Webb just described it as a high-level piece of legislation with a lot of work being then devolved to rules that will be created. We would have a concern that there is a scope for rules to certainly broaden but also narrow rights. And so the preference would be that these sorts of issues, and agreed, where it's very difficult to comment, we've raised this when the charter obligations are not yet settled or made public. So that aligns with concerns that we have raised. I might just defer to my colleague, the Commissioner, to see if she's got any additional observations she'd like to make in that regard.
Thank you, Rachel. It's really hard to gauge what might actually eventuate, but the protection, the scope of the framework is critical. Unless we have an understanding of that, then you're just sort of clutching at straws about how it's going to operate. And again, we come back to the duplication. And for us, a no wrong doors approach, coming back to previous questions, a no wrong doors approach is fine, but it needs to have clear guidelines of how it's going to operate effectively. So a referral system, you can have an initial complete case management startup, but you need to have a strong guideline of the way in which referrals are made and how you choose which is the best complaint system to refer it onto to handle it. So, and that's going to be critical in the area of accessibility.
Okay. Senator Goodell, just...
Yeah, no, this is the last question, so yeah. I'll just get the other answers.
Thank you.
I would just briefly say on behalf of the Australian Lawyers Alliance that we have previously been advocating for a passenger Bill of Rights, which would set out the rights and obligations in primary legislation. We do broadly support this bill because it's an improvement on how things are at the moment. But yes, we agree that our position has been that a passenger Bill of Rights with the rights and obligations in primary legislation would have been ideal.
Thank you.
Yes, we agree. The primary rights and obligations should be set out in the primary legislation with the charter and standards to provide operational and technical support to those primary obligations.
Thank you.
Thanks, Ms. Webb. Thanks, Senator Cadell. And I welcome Senator Mulholland. Senator DeLiga.
Thank you very much, Chair, and good morning, everyone, and thank you for your contributions so far. My question is to Ms. Webb, and to sort of follow on from some of Senator Cadell's questions regarding the delegated legislation. So do you accept that there are practical advantages in maintaining flexibility in a technically complex and evolving operational environment like legislation?
I do. There's plainly a place for delegated or subordinate legislation, but I don't think that is in the place of the principal rights and obligations which we consider should be specified in the principal legislation, with the delegated or subordinate legislation, of course, having the flexibility that's needed, and that is why we have those processes available to us.
And so ensuring adequate parliamentary scrutiny and oversight with the delegated legislation, do you think how do you see that?
Well, I think that if the primary legislation includes the core obligations and rights, and ideally the proposed charter and standards would be prepared and available for discussion and debate at the time of the legislation, and I think that's an appropriate approach where there's some flexibility, but also there's robust scrutiny and engagement on the whole package.
And do you see that if all the operational standards were fixed directly in primary legislation, would it reduce the system's ability to adapt efficiently to emerging operational or customer issues?
I think if the standards are truly operational or technical, then I don't think that level of detail needs to be specified in the primary legislation. That would be appropriate for delegated legislation. What the Law Council's position is that delegated legislation shouldn't be the place for the primary and most important rights and obligations that this package seems to contemplate.
And I do, and I note in your submission that the charter itself is not currently before the Parliament. If the exposure drafts are publicly consulted on and the charter remains a disallowable instrument, would that address substantial portions of your concerns?
In part, our principal position is that the core rights and obligations that will be covered in the Charter should be specified in the primary legislation and mandated in the primary legislation. So that, together with consultation on the Charter at the time, would address our concerns.
And I just want to ask about, in your submission, you note that you support stronger accessibility and child-related protections. Do you regard these as areas where minimum enforceable standards are particularly appropriate?
Yes. Our point on those matters was sort of consistent with the points that we've been discussing throughout, which is that they are important matters, and the legislation at the moment doesn't mandate that they be addressed in the Charter, and I think that should be addressed. And
in September last year, there was a draft consumer standards document that was published for public consultation. Did you participate in that process, in that public consultation process?
I personally didn't. I'll have to come back to you on what the Law Council did.
Okay, thank you. And I might just ask, in your view, when disruptions occur, do passengers generally prioritise getting to their fixed destination with timely information and practical assistance ahead of receiving a fixed compensation payment at a later date?
What passengers might prioritise is not something that I, as representative of the Law Council, am really in a position to speak to. I'm sorry.
I might just ask Miss Kayes or Miss Holt if you have a thought, or Miss Roy.
From my perspective, in terms of the complaints that we handle, it's as varied as humanity itself. So for some people, the success of their journey is of paramount importance. For others, redress after the fact is something that remains very important to them. So it's very individual specific. Sorry if that's not very helpful.
No, I understand. Miss Kayes, did you, or Miss Roy, did you want to?
No, I mean, the complaints data is one thing. I mean, personal experience is, getting everything there in one piece is generally the main objective.
Thank you.
And the Australian Lawyers Alliance, we don't receive complaints, but the feedback we do get from consumers is that they just want to get what they've paid for, and unfortunately, that isn't what's happening.
And I might just ask Ms. Kays, how important, given your role at the Commission, how important is communication, respectful treatment and certainty during disruptions for passengers with disability compared with purely financial remedies after the fact?
Critical, absolutely critical. That's where the greatest breakdown will occur in a relationship. And it doesn't matter whether it's in other retail services, whether it's in education, whether it's in employment. If people are constantly confronting paternalistic, demeaning approaches and a lack of communication and a lack of respect for their concerns for their mobility devices, their concerns for their individual autonomy and their safety in, being physically manhandled when you've got to transfer from small aisle chairs into aircraft seats, then, without that communication, without that understanding that, people need to be aware of a situation to be able to access it not only safely but with dignity. And so, yes, that is absolutely critical. Those might seem trivial to some people, but they're small microaggressions that people confront time and time again and can really break down relationships.
Thank you very much. And I might just ask my final question. I think was it Miss Holt that made concerns about the exemptions for the passengers in airports with less than 1 million passengers per year? I'm sorry, I can't follow my own note here as to, or was that you, Miss Roy?
That was me, Senator, yes.
Thank you. And I just wanted to ask you whether or not in thinner or regional markets could highly prescriptive compensation obligations unintentionally affect route sustainability, resilience and frequency, particularly where there's the routes already operate with narrow margins and limited redundancy?
I'm afraid that's not within my expertise, Senator, the Australian Lawyers Alliance. But what I would say is that we are very concerned that regional Australians rely heavily on aviation and in particularly to access specialist medical treatment. So a lot of the members of the Australian Lawyers Alliance, our day jobs is plaintiff personal injury work. So we see people with serious injuries and access to healthcare in the regions is already a concern in some areas.
I'm from Tasmania, Miss Roy, and particularly I hear from the people in areas like King Island all the time who rely on aviation to get healthcare. Absolutely, yeah. I hear that.
Yeah. So an exemption of these regional airports is as Ms Webb said, having an exemption in the primary legislation already is a concern, but already having an indication that the government intends to exempt these regional airports is a big concern for us.
All right, no worries. I'm just conscious of the time, Chair. I might pass the call back.
Appreciate that. Thank you, Senator Deleega. So to the witnesses, thank you very much for your evidence today. And we will now call Choice via video conference. They'll be joining us through Mr. Kelly and Mr. Campbell. The Consumer Champion, Mr. Gleeser, and from Justice and Equity Senator, Ms. Balakrishnan. Via video conference, by the way. Sorry. I'll check with Hansard and Broadcasting. Witnesses good to go? Yep. Thank you very much. Tremendous. Now, I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you all. And for the Hansard record, if you could please state your full name and the capacity in which you appear today. And because you're sitting right in front of me, I'll start with you, Mr.
Beautiful. Adam Gleeser, advocate, or consumer advocate, whichever, from Consumer Champion.
Thank you. Welcome. So, Choice, are you there?
Good morning. My name is Andy Kelly. I'm the Director of Campaigns and Communications at Choice.
Thank you.
And I'm Morgan Campbell. I'm the Head of Policy and Government Relations at Choice.
Thank you very much. And Ms. Balakrishnan.
Good morning. Sheetal Balakrishnan. I'm a Senior Solicitor at the Justice and Equity Centre.
Thank you very much. Now, would you like to make a brief opening statement before we go to questions? And I'll start with you, Mr. Gleeser.
Yeah, thanks. Thank you for the opportunity to appear before you today. I would like to acknowledge the Interim Ombudsperson Samantha Palmer and the team for the work undertaken. Some elements of the draft charter are a step in the right direction. For instance, I welcome the proposal allowing consumers to be rebooked onto alternative flights, including with competing airlines, as well as stronger transparency requirements around the conditions of carriage and consumer rights. However, more reform is still needed to adequately protect Australian consumers. Firstly, terms in the draft charter such as reasonable efforts, best efforts and reasonable time need to be clearly defined. Leaving these obligations open to broad interpretation creates uncertainty and disadvantages consumers as it has in the ACL. Secondly, a notable omission from the draft charter is the absence of any financial compensation. Where cancellations, significant delays or involuntary bumping occur within an airline's control, consumers must be fairly compensated. International jurisdictions have been financially compensating customers and providing refunds for all cancellations for years. In the EU, passengers may receive compensation of up to €600 for significant delays or cancellations within the airline's control, while in the US, passengers involuntarily denied boarding due to overbooking may receive compensation of around $1,550. Thirdly, refunds. Refunds must be available for all flight cancellations, regardless of the reason. The principle is simple. If consumers pay for a service that is not delivered, they should receive their money back. The lessons from COVID should have settled this issue long ago. Finally, the joint industry submission shows a disconnect between the position of the airlines and the lived experience of Australian consumers. Claims that stronger consumer protections would substantially increase airfares or reduce competition are difficult to reconcile with international experience. For example, Qantas already operate under significantly stronger consumer protection regimes in the US, EU, UK and Canada, which raises a simple question. If these protections are workable elsewhere, why are Australian consumers considered less deserving of them? Refunding consumers for services not provided and compensating passengers for avoidable disruptions are not radical proposals. They are fundamental principles of consumer protection.
Thank you, Mr. Gleeser. Now to Choice. Mr. Kelly, I believe, would you like to make an opening statement?
Thank you. Good morning, Senators. Thank you for inviting Choice to address the committee this morning. We've been hearing horror stories from travellers for many, many years, but the COVID-19 pandemic really exposed the gaps in Australia's lax aviation consumer protections. We saw consumers lumbered with deliberately difficult to use credits with short expiry dates, difficult to access customer service, Some consumers had to go to extraordinary lengths to get to their destination or to make an important event like a wedding or a funeral. When complaints went unresolved, consumers could only really turn to the dismal industry-funded airline customer advocate, which received a Shonky Award from Choice for being little more than an email forwarding service for consumers. Far too often, consumers are given the runaround by airlines when trying to access a remedy for a delayed or cancelled flight. Travellers are often not even given a reason why their flight has been delayed or cancelled. This information asymmetry gives airlines significant power because consumers aren't even given the information that they need to know what remedy they're entitled to by law or by contract. We welcome and support the aviation bills to address these issues, which establish an independent ombuds scheme, something Choice has been calling for many years to help resolve consumer complaints and provide a pathway to redress. We're pleased that feedback on its independence has been reflected in the bills. Choice also welcomes the creation of a new regulator to enforce obligations on entities and the Aviation Consumer Rights Charter still to come, which will set out protections consumers should expect. We broadly support the bills and believe they should be strengthened further. We're concerned that the new regulator's functions will sit within the Department of Infrastructure. The Aviation Consumer Protection Authority should be independent. We appreciate that the new regulator will benefit from being established within existing infrastructure. However, we believe that within the ACCC would be a more appropriate initial setup. The regulator should be free from ministerial direction and influence on daily decisions. If the regulator is to sit within the department, a statutory review should be included to consider its performance and positioning. We are also concerned that the minister will have broad powers to exclude any entity from the entire regime indefinitely. If an exemptions power is included, appropriate guardrails like time limits or conditions should be imposed on any exclusions, which should all be open to public consultation prior to being granted. Otherwise, the legislation and protections it offers to consumers could be hollowed out over time. And finally, the regime will only work if the promised Aviation Consumer Protections Charter is strong. As you are aware, most of the core consumer rights and obligations on airlines and airports will not be set out by the bills before Parliament, but by a legislative instrument, limiting parliamentary scrutiny. We have seen some good improvements since the initial draft of the proposed charter, but we're concerned that the final charter may still not go far enough to protect consumers from a future pandemic, or as we've seen recently, the impacts of acts of war. Existing consumer laws are inadequate, so the charter must go much further than simply reflect the existing law. Thank you for your time. Mr. Campbell and I are happy to answer any questions.
Thanks very much, Mr. Kelly. Now, Ms. Balakrishnan.
Thank you to the committee for the invitation to appear today. The Justice and Equity Centre has a long history of working in public policy and advocacy to promote the rights and equal participation of people with disability, including access to air travel. Our submission draws both on our policy work with disability advocates and our legal practice representing people with disability in complaints against airlines and airports. Through that work, we hear regularly about the barriers people with disability face at every stage of the travel journey. When services are inaccessible or not delivered as promised, the consequences are serious and disproportionate. They can affect people's safety, dignity, and independence. The scale and seriousness of these experiences shows that existing legal frameworks are not working effectively. So in that regard, we welcome the Aviation Consumer Protections Bill and particularly its recognition that protections for people with disability need to improve. There are, however, key areas where it should be strengthened to ensure that those protections are meaningful in practice. I will briefly highlight 5. First, the framework should apply across the entire travel journey. The government's intention is to exclude security screening, and in our opinion, that would be a significant gap. Airport screening is widely recognised as one of the most difficult stages of travel, especially for people with disability. Excluding a stage that is associated with well-documented systemic issues would undermine the effectiveness of the framework. Second, protections must apply to all consumers. The government's proposed exemption of small airports risks creating uneven protections, particularly for people in regional and remote communities where air travel is essential. People with disability are already disproportionately affected by service failures, and that impact is greater in the context of small airports where alternatives may be limited. The framework shouldn't entrench geographical inequality. Instead, it should adopt flexible mechanisms that ensure consistent protections, and in our submission, we suggest ways this could be done. Third, the bill must properly recognise disability aids. While it addresses baggage handling, it does not adequately distinguish disability aids. Disability aids are not a subset of baggage. They are essential to mobility and independence. When they are damaged or lost, the consequences are far more serious than for ordinary baggage. The legislation should explicitly reflect that. Fourth, we support the proposed Ombud scheme, including its balanced governance model. However, with accessibility being a core objective, people with lived experience of disability need to be properly represented in decision-making on the board, and this should, at a minimum, be 2 consumer directors and should be guaranteed in the primary legislation. Finally, the Ombud scheme adopts a legalistic merits review approach to decision-making. In our view, this is not well suited to an Ombud's model. Comparable Ombud schemes, such as AFCA and the TIO, apply a standard of fair and reasonable in the circumstances, which is more accessible and better suited to resolving consumer disputes. This bill should adopt that approach. Our submission makes 33 targeted and technical recommendations to constructively improve the bill, and I'd be happy to take questions. Thank you.
Thank you very much. Senator Cadell. Senator Colbeck.
Hand pass. Thank you. Mr Gleeser, you raised the question, why should Australian consumers receive less consumer protection in the US and EU and the other jurisdictions you name? Why should they?
Why should they?
Yeah.
They shouldn't. It's they should be getting.
That's what you'd say. That's what
yeah. It's
I just wanted to put. Put on
they simply should be. And look, at least there's literally the gap between the other jurisdictions in Australia is massive. I mean, all you've got to do is look at Qantas's conditions of carriage for each. I was having a look at them last night. For each jurisdiction, and Australians are treated terribly in comparison. That's the reality of it.
So do you think the bill really provides sufficient powers to drive systemic change, which is what you're talking about, on cultural change across the sector, rather than just creating a complaint system?
I think it will definitely, in my opinion, it will drive change, not a complaint system, because you've got as long as everything is set out in terms of, if I'm answering it correctly, if I'm not, stop me.
Well, does the bill do enough as it sits now to make those changes?
Not even close.
That was what
I was
asking.
sorry, not even close. Yeah.
So it really doesn't drive systemic change as it's currently structured.
No.
It's providing some change, and
it's providing minimal. It's providing some change, minimal change, but it's got to be weighed up with the ombudsman scheme or ombudsperson scheme. Is it going to be, when it comes to we've got to weigh it up with how much it's going to cost the taxpayer? If these are all the changes that are going to be there, is it going to be worthwhile? Because it still doesn't address the 2 core issues, which are automatic refunds for all flight cancellations without some of these bizarre exceptions I've been told about. And as well as that, compensation when the issues are within the airline's control. We're inconveniencing the public. I mean, what happens if they're going to a family member's funeral, wedding, and it's the airline's fault, they miss it, or they've got to be compensated, and it's also a way of deterring this type of behaviour from airlines going forward. Like anything, like with a young kid, it's punishing them for doing the wrong thing.
So more broadly, with respect to the enforceable protections for passengers of disability, there's been a lot of discussion with respect to the definitions and the scope within the bill. Can I just get thoughts across the board with respect to that from members of the panel, please? Might start with Choice.
My apologies. Could you repeat the question for me, please?
So the question being adequate enforceable protections with passengers with disabilities. Do you think the bill effectively does that? I'll come to you next, Ms. Balakrishnan. But it's directly relating to the issues with respect to support for people with disabilities.
Yeah, look, I think, a lot of the questions that are going to be around the protections for consumers and protections for consumers with disabilities, or protections generally, a lot of the devil is going to be in the detail of the Aviation Consumer Protections Charter, which isn't part of the bill that lays the groundwork. So a difficult question to answer, but the question about passengers with disability isn't our area of expertise.
Okay. Ms. Balakrishnan.
Senator, would you like me to...
Yes, please.
Yes, thanks, Senator. Yes, in our submission, we do make several recommendations about enhancing the definitions of some of the key concepts. So we've made some recommendations around the definition of accessibility service to be more inclusive, and we've suggested particular wording that could be amended in what is currently proposed in the bill. We've also suggested that the definition of airline service could be made more broad to ensure that it captures all aspects of the air travel of the air travel journey that's associated with what the airline service provides. In relation to airport service, that's probably the biggest point with the definition in terms of what I raised in my opening statement about that not currently including security screening. So our strong recommendation there is that security screening is included within the scope of the framework. And then we've also suggested a change to the definition of airport accessibility service to clarify that that can be provided by both an airline and an airport, not simply because it's called an airport accessibility service. So there are some good bases to work there, but we've certainly suggested ways that those definitions can be enhanced.
Okay. So there's already been discussion about where the standards sit with respect to the bill or in delegated legislation. Would you support them being more defined within the legislation rather than the delegated legislation of the regs?
I'm happy to start on that question, Senator. So I can say that we at the JEC did participate in the consultations that were run by the department towards the end of last year on both the primary and subordinate legislation. So we have also, I think similarly to Choice, seen various iterations of what's proposed in terms of delegated legislation for the Charter. I will perhaps make two comments. So the first is that currently the bill provides that the Minister may establish the Charter and may establish the Ombud scheme. And so I think that wording of may, from our perspective, seems a little bit problematic. While we appreciate that that is giving way for flexibility and the adaptability in terms of the discussion that's been had in the earlier session, and while we also appreciate that the intention is to make both of those things, it's not clear from our perspective why it would be necessary for those powers to be discretionary in the way that they've been framed in the current bill. So we would be suggesting that those become mandatory so that the Charter and the Ombud scheme are established as and provide certainty in that regard. The concern being, I guess, that even though the current government has stated its intention to create both of those things, a future government may decide to revoke the creation of both of those aspects. The second recommendation we've made in terms of going to the point about delegated legislation is also that there should be a statutory periodic review to ensure that those pieces of delegated legislation remain current and have opportunities to be updated as necessary. Thank you.
Joyce?
Yeah, thank you, Senator. I don't think we have an issue with the Charter being a delegated legislation in principle, but I think to the point made by Ms Balakrishna, the ability to the discretionary element of what's currently proposed is problematic, and there's no real reason for it to be a may rather than a will. But having the Charter as a delegated instrument does have some benefits as well, more broadly, around being able to be updated more frequently without having to go through the full legislative process.
Do you think the legislation would benefit from having some better direction with respect to navigation? It covers a whole range of different jurisdictions. There's overlaps. And so how do we... I mean, if someone's got a problem with the airlines, they're going to go through the airline process to get access to whatever support or compensation or whatever they're seeking as a part of the process. How do we make sure that the navigation of that is appropriate for consumers from any perspective in the way that they're looking to have their complaints addressed?
There are probably two parts to that from our perspective. One is, to the point that Mr Kelly made earlier, the detail of the Charter and further to that, the way that the Charter is drafted is a really important part of the way that consumers are going to navigate this whole process. That is ultimately going to be the source of truth around their rights. And so that needs to be as clear as possible, and those rights, as well as needing to be strong, need to be really kind of clearly articulated. And also to the point that JEC have made, we also support a statutory review to see if there are kind of whether it's unintended consequences or particular difficulties that consumers are facing in trying to understand their responsibilities in the way that the Act, if it is to be an Act, works.
Ms Balakrishnan?
Thank you, Senator. So, yes, I would agree in terms of the clarity that's needed to ensure that people or consumers aren't being left to navigate complex complaint systems. I guess from the work that we do, and the types of issues that people with disability have raised with us in terms of their air travel experiences, that sometimes their complaint simultaneously raises consumer law issues and potential breaches of discrimination law. The remedies that are available for consumer law issues are different to the types of remedies that one could get through a discrimination law forum. I guess in terms of this case, the Ombuds scheme is aimed at providing remedies for individuals to undo the unfairness that someone has experienced. So that might be, for example, quicker practical remedies such as refunds or compensation. But discrimination law has other tools for addressing perhaps underlying systemic problems. So, for example, changing discriminatory policies and practices of an airline or an airport. So it really, consumers need to be able to have a choice in terms of what kind of process and outcome they're seeking, especially given the different types of remedies that can be gained through those different avenues. So clarity is definitely needed. And then on top of that, we have also recommended in our submission that there needs to be cooperative and proactive working arrangements between the Ombuds scheme and the other relevant bodies, so that consumers are provided with clear, timely information about their avenues for redress, and at the same time that the bodies are also working together in the collective goal of improving and making systemic improvements to the industry.
Mr Gleeser.
Yeah, I've got something on that one. In the US, hot off the press, about 3 days ago on April 26, it was introduced that the airlines need to have a one-pager that in layman's terms sets out exactly like the main rights that consumers have when it comes to things like refunds, cancellations and the like, not hiding them like some insurance companies do at the bottom of a PDS, but just so it's there for them to see so they know their exact entitlements. And that's something that would be extremely handy here so that everyone can navigate it, and as well as that, in the interest of transparency.
Okay. So there needs to be, in that sense, from every perspective, an appropriate process for navigation and dealing with the relevant aspects of a particular complaint through the way the system operates, and that needs to be properly explained to consumers as part of this process. Can I just ask each of you, with respect to the exemption powers in the bill, and to give us some clarification with respect to those? And I'll start with you, Mr. Gleeser.
It's I'm not 100%. Can we start with one of these with
Sure,
them?
Sure. I'll go to you, Ms. Balakrishnan.
Thank you. So in terms of the exemption power, we have previously recommended, in terms of the consultation we participated in with the department, that there could be a tiered membership model to account for variations in the size and operations of regulated entities. So that is one way that exemption power could be utilised. In terms of passengers with disability, in our submission we've suggested, and particularly in the context of small airports, and appreciating the rationale that's been given by the government in terms of operating capacities and resources of those kinds of entities, in our submission we've suggested ways that the exemption power should be improved to still prioritise the rights of passengers with disability. So, for example, that the exemption power could be narrowed to prohibit exemptions from compliance with the charter requirements that go to accessibility, and also to narrow the exemptions so that complaints about airport accessibility services could still come within the scope of the framework. So that's one way that we have suggested that the exemption power could be improved. Another way would be to ensure that any kind of exemption is time limited, particularly when it comes to accessibility related obligations, and also complaints again about those accessibility services. And then a third way we've suggested is to require, so particularly around subclause 9(5)(c), that the Minister expressly consider the impact of an exemption on people with disability in addition to the general impact on consumers. So in our, I certainly don't mean to suggest that these are the only ways that the exemption power could be improved, but these are the ones that we've suggested and could be used in a way that preserves flexibility for entities like small airports while ensuring that the framework still delivers consistent protections for people with disability.
Joyce?
Yes, and if I can just quickly add a point on the previous question about navigation. Choice has been recommending that there's a requirement on airlines to proactively identify complaints. So in financial services, the phrase is any expression of dissatisfaction should be treated as a complaint. And so we wouldn't want a situation where consumers have to, say the magic word of like, I'd like to make a complaint in order for it to be treated as such, to enter into, a complaints process with the airline to then get to the ombud scheme. So that's something that we've been recommending, and also that the reason for the delay or cancellation is provided, including clarification about whether that is within or outside the airline's control, so that the consumer knows what remedy they're potentially entitled to in that situation. On the current question on the exemptions power, so we have recommended that there needs to be a process here where appropriate guardrails are put in place. So conditions imposed appropriate to the entity seeking an exemption, a process to apply for one. It should be open to public consultation. There should be time limits. There should never be an indefinite exemption provided. The government could also consider other ways to assist smaller operators, smaller entities to comply with the framework, with the charter, as well, as opposed to just exempting them entirely.
Thank you. I just want to go back to the discussions around definitions and the definition of the term, for example, reasonable efforts, and how that is appropriately defined so that it doesn't become something that the airline think that they might have done rather than have a specific obligation. So where should we be sitting with that? Should we be aligning it more with other elements of consumer law, or how do we improve the definitions in that sense? Mr. Gleeson?
Look, and I actually had one thing as well that I just wanted to quickly mention in relation to the exemptions. Look, it's a tough one because, you know, the smaller operators, entities and airlines, it still affects the consumer in the same way. So it's a bit of a tough balancing act with that. I think they should have to not necessarily prove, but let's say, for example, which I know that airlines are opposed to, them needing to put customers on a different airline entirely because to get them to their destination in a prompt period, they should have to actually see and actually try to get them on, let's say if it's Qantas and they've got to go to Virgin, that they should actually have to go and try to get the customer on that flight. And if it's either sold out or there are no flights left, that's obviously a reasonable effort. But just being able to, it's got to be defined where they actually do something proactive to at least attempt to get the result, even if it is costing them a bit, because otherwise there's no point in having it in there because they can just say, yeah, we've tried, we've given it a reasonable effort.
Joyce?
Sorry, I'm keen to give the opposition as much time as we need.
No,
can you have one more and then we go to Senator?
Well, I just want the other two witnesses, if they can answer that question, and I'm happy to rotate.
Thanks, Senator Colbeck. Joyce?
Perspective on that from Joyce?
I'm happy for Justice and Equity Centre to take this one if you prefer.
Okay.
Oh, thanks, Mr. Kelly. I guess I was going to say that it's not something that we've referred to in our submission directly, and our expertise has been focused on the issues for consumers with disability. So I'm not actually sure, Senator, where the reference to reasonable efforts is appearing in the bill.
Well, I suppose it's more about what the airlines say and how we properly define what their obligations should be under this legislation. There's been a number of references in submissions to the definitions, and so my question relates to how we ensure that those definitions and the fact that the definitions aren't adequate. So my question to you is how we ensure that they are. Well, I mean, what do we look at in that context?
I can speak generally in terms of drawing on my legal expertise, and when we come across vague terminology in legislation, it certainly doesn't assist in terms of people being able to preserve their rights or vindicate their rights. So definitions certainly need to be clear and not raise any sort of unintended consequences or interpretations which make it difficult for consumers to then be able to stand up for what their rights are in this legislation.
Thanks, Chair.
And if I can just add quickly to that, I think, and this is back to the point of like the core obligations in the Charter will be determined later, but, making sure that, the consumer has the right to a refund as a first option rather than allow the airlines to do basically everything else except give a refund, and then only as a last resort you get the refund. The consumer should have the choice.
Yeah, okay. Thank you.
Thanks, Senator Colbeck. Senator Mulholland.
And thank you to our witnesses for joining us. I would just first like to go to your choice in particular. Your submission talks about the proposed charter being, below the compensation models that we're seeing elsewhere in Europe and Canada. I had a little look up at some of those compensation models myself just to get a bit of a sense of it. The Canadian one has compensation if you're delayed by 3 to 6 hours, 400 Canadian dollars, 6 to 9 hours, $700, or 9 or more, $1,000. And similar sort of dollar figures for the European model. What I wanted to ask you about is that I think we're all pretty much on a unity ticket here, that we're sick and tired of airlines trying to shirk their responsibilities around refunds. The number one thing that people talk to me about is not wanting compensation. They actually just want their damn refund. They want, if they've been cancelled, they just want their money back sometimes. And I think that's, that comes through to me as a sort of a first principle from people. So I would like to just come to you around those considerations. When I hear from consumers, they talk to me about wanting, they want to get on the flight, or they want to get on a reasonable other flight. They want to get their money back as sort of a first principle, rather than wanting to seek additional compensation. I'll sort of open that up to you for your comment.
Thank you for the question. And I guess in relation to the charter, I mean, again, it's difficult to talk about because we don't know exactly where it's going to land. I guess the first thing I will say
just on that, have you been consulted on versions of the charter? So you have seen versions of the charter from the government?
Yes, we've been engaged throughout the process. I guess in terms of what consumers want in these types of situations, I guess it really depends on the consumer. However, under the existing consumer law and under consumer guarantees, which apply to services, the goal of the law is to put the consumer in the position that they would have been in had the breach of the consumer guarantee not occurred. So providing the service within a reasonable time frame and with due care and skill. So there is existing law that applies to this situation, and that goes beyond just a refund or a rebooking of the flight in certain circumstances. So in particular, when it's within control of the airline, or more specifically, not because of the actions of a third party, the consumer may also be entitled to compensation already under the consumer law. And these bills give a pathway for consumers to achieve that through making a complaint to the airline, but also going through to the external ombud scheme to try to achieve that. Of course, set compensation amounts has benefits. It's a much more efficient system because less people will most likely need to go through to the ombud scheme in order to get compensation. And that's, could consider things like, okay, well, I've, also lost all these future bookings that I've made, or I have really no reason to travel now because I missed the funeral or the wedding. And, there are other things that need to be made right.
JEC, do you have a comment?
Senator, I will defer to colleagues on this panel who have expertise in terms of general consumer law issues because of our expertise focusing on people with disability. Thank you.
Thank you.
Yeah, I've got something.
What?
Sorry,
Pardon?
Sorry, Senator Mulholland. Mr. Glazer would like to.
Yeah, sorry, Hunt.
Sure.
Yeah.
Just from my background, I did catch your opening address before. So are you working in sort of an advocacy space, or are you?
Yeah, I'm an advocate.
Do you have is it a fee for client process that you're working on behalf of people, or are you sort of a free advocacy advice service? Just so I could get
I've got a paid service, but this type of thing, I obviously don't charge for the the things like with the rules and the laws for airlines. I don't get paid anything for, but I have got a business called Consumer Champion, where there is a no win, no fee thing. Okay, so with this, most Australians aren't aware of the overseas models, and when I let them know, they're generally outraged. So when I know you mentioned that most constituents don't mention anything about the compensation side, that's because most of them don't know about it. And I noticed that Andy before mentioned about compensation. What compensation? There's no financial compensation now. You might get $8 at an airport to get some food, or something nominal, but there's no level of financial compensation available in Australia at the moment unless it's under a different country's laws.
Thank you. The one thing that I'm from Queensland. We've got a number of regional airports. We've got regional airlines that are hanging in there. We've had Rex go to the brink and come back. We've lost Bonza. We've lost Tiger. We've lost a lot of low-cost airlines. We've got a lot of regional airlines also hanging in there. What concerns me is around any other additional financial burdens that are going to create, I think, challenges, particularly in the regional aviation market. I know that there was a bit of discussion before about the exemptions, the carve-out for regional airports. I would hate to see a situation where we have a system in place that unfairly sends our regional airports and our regional airlines to the wall, and then the people who live in my state don't have an airline at all to get on to medical appointments because they need to get to Brisbane, to get to work, to get to mine sites. So that's my concern. I would welcome your advice about your feedback around the exemptions and the carve-out for regional airlines.
That question is to all of you, I gather. So whoever wants to put their hand up and answer, go for it.
Sure. Yeah, I'm happy to speak to that. And just quickly to respond to Mr. Gleeser's comment about compensation. As I said, consumers are in certain circumstances entitled to it, just to clarify the existing law. However, we see the problem of actually accessing it. So there's nowhere to go in terms of external dispute resolution at the moment in order to actually receive it from the airlines. But as I said, set compensation amounts, much more efficient way of doing it, but it may not completely cover somebody's costs if you go down that route as well. On the exemptions front, I completely appreciate the complexities and challenges, and this is something that we're very concerned about as well in terms of consumers being able to access affordable services. That's obviously the most important thing. However, we don't believe that should come as a trade-off for consumers' rights and protections. That they should still be protected, and that perhaps there's a role for government to think about ways that it could help regional airlines, regional providers actually comply with the law and provide the same level of experience to consumers by way of grants or other things. We don't think that consumers should pay the cost there, but it could be dealt. My apologies. I was just going to add that. I'm so sorry. I was just going to add that, the exemption framework, if it stays there just has to be appropriate guardrails in place. And so, these are important things. They affect, particularly regional consumers. And so if in a regional airport or a particular airline is going to be exempt, that should be open to public consultation. People should be able to have their say on that. And then from that process, appropriate conditions and timeframes put in place around that exemption.
Mr. Gleeser, did you wish to?
Thank you. And I think it was the JEC evidence was around wanting to see the inclusion of screening to also be included into the consumer protections. One of the things that I think we're going to get a bit of evidence later today from the Pilots Association. They are quite concerned broadly about compensation and inclusion of things like screening, not to want to put words in their mouth, in reading their evidence that airlines will be driving to get people onto planes when pilots and crew think it's not safe to do so is one issue that they've raised, and they're really worried about that. There's also a real concern about trying to put a consumer overlay over what are regulatory pieces that particularly Australian Border Force operates at screening processes and are upholding the laws and some pretty significant restrictions and biosecurity and all sorts of stuff. Trying to put a consumer overlay over that is something that we've also had some concerns raised with us about. So I would like to just ask you about your submission where it proposes entities like Border Force and Air Services Australia come within this framework? And do you accept that there is a fundamental difference between commercial passenger services and government functions like border control and air traffic management, and trying to bring that into a consumer lens could be problematic?
And before the witnesses answer, I'll just remind that we are on a hard time. We've got about 4 minutes left of these witnesses. So please, go for it. Mr. Glaston.
I was going to. Oh, sorry. I was going to. All I was going to say with that one was, if you're talking about refunds and the like when it comes to issues with border security, I didn't. If I'm understanding the question, customers should always be refunded for any kind of cancellation, irrespective of the issue. And yeah. Sorry.
What if they've broken the law?
Fair call. If they've broken the law, like if they've gone and broken the law, as that's not a cancellation of the actual flight, that's them being booted.
Well, their flight would be cancelled. Yeah, it would be.
Oh, well, if the individual...
You're not getting on the flight,
okay,
it'd be cancelled for you.
Well, we're talking about very specific situations, but, Senator, I do not believe that customers should be entitled, if they have gone and broken the law or they are too intoxicated to board, that is the one situation I do not believe that they should be entitled to a refund. Them specifically, the others on the flight, they should be, but the ones that have caused it, absolutely not, because the others have done nothing wrong. They're not getting the service they paid for. But yeah, no, I agree with you on that one.
Okay.
Thank you. We might just quickly come to JEC, because that was in your submission around adding in screening.
Yes, so I mean, Senator, we didn't sort of name check Border Force or Air Traffic Control, but we just, in terms of security screening, and our understanding being that that's sort of regulated by Department of Home Affairs at the top level. So I guess our view is that security screening, whilst it doesn't have that commercial element, so to speak, that is trying to be introduced through this bill, there are other services that are going to come within the scope of the bill that don't require those kinds of direct payments from consumers. So airport accessibility services is one of those. So security screening, in our view, could be covered in the same way, notwithstanding the fact that there's no sort of direct payment required by consumers. In terms of adding that extra level of consumer law to what is already a differently regulated space, I guess what we've said in our submission is that security screening poses well-documented issues for consumers, and the types of obligations that we would be wanting to see are things like appropriate training by security screening, treating people with dignity, respect, ensuring that they are following, we've heard examples of people being separated from their disability aids. So they're just treating people with dignity and respect. So I don't think that those would be overly burdensome on top of their other regulatory frameworks that they've got to operate within.
Thank you. Chair, I might just ask one follow-up question, if I may, very, very quickly.
Yes, of course.
Mr. Gleeser, you mentioned in your evidence earlier as a champion of consumers that you have a no-win, no-fee system. Would you stand to financially benefit from a mandatory compensation scheme?
No. I certainly would.
Or would you benefit for any types of compensation, or like
they do that.
if you were assisting a consumer with an issue, would you?
I'm an advocate. I'm not a lawyer. I don't. Their help in the UK and EU do that. That's not my caper.
Just wanted to double check. Thank you.
Not at all, mate.
Evidence. Yep. Thank you.
All right, on that, thank you very much to the witnesses, and I appreciate that. Thank you, colleagues. And we will now call our next tranche of witnesses. We will be calling, Mr Westerway and Miss Hazelwood from the Australian Airports Association, Mr Byron and Mr Thompson from Canberra Airport, Mr Charlton and Miss Geraghty from Sydney Airport. I'm just thinking we're probably your biggest clients. So welcome everyone, and we will invite you to make a brief opening statement, and then we'll go to questions, and I shall start from my left. I know you will sort out amongst yourselves. Miss Hazelwood or Mr Charlton? No? Yes, Miss Hazelwood. Sorry, Mr Westway. Where's Mr Westway?
Yes,
Oh,
it's
there
Mr
you are.
Westway. He's on the
Sorry,
screen.
where's your name?
My name is Natalie Hazelwood.
Oh, sorry.
No,
I should
that's
put my
okay.
glasses on. Oh, someone's on the air.
Yeah, Simon's via video.
Oh, God. Can I tell you,
Chair.
I hate this technology. It's written for me. I don't even see it. Okay, thank you. Okay, Mr Westway or Miss Hazelwood?
Morning, Chair. I'm in your home state of Western Australia this morning.
Oh, you lucky devil.
No, it's been good over here. Thank you for the opportunity. So thanks, Chair and Committee, for the opportunity to appear today. Now, the Australian Airports Association represents more than 340 airports and aerodromes across the country, from major international gateways to many regional and remote airstrips. Airports are more than transport infrastructure. They connect people to family, work, tourism, trade, essential services and community. For many regional and remote communities, airports help people access medical treatments, education, emergency relief, the mining industry and connect remote Indigenous communities. Consumers deserve an aviation system that is fair, transparent, accountable and responsive when things go wrong. Australian airports share that goal. Across the country, airports are investing heavily in customer experience, accessibility, inclusion, infrastructure and amenity because we understand that every passenger journey matters. Aviation is a highly complex system involving airlines, airports, government agencies, border agencies, local government to ground handlers and contractors, each with distinct operational responsibilities. The overwhelming majority of aviation consumer complaints relate to matters controlled by airlines, including delays, cancellations, scheduling, ticketing and refunds. The government's own comprehensive aviation consumer survey showed that only 5% of complaints were about airport transport or parking options and 5% were about security screening procedures. The large majority related to issues with direct airline control. 46% were flight delays, cancellations or changed itineraries, while only 22% were baggage complaints that the airlines are responsible for. Essential principle of the framework must be that accountability follows operational control. The AAA also considers it critical that the legislation avoids unintended scope creep over time. The scheme should remain focused on genuine aviation consumer matters connected to the passenger journey and should not unintentionally expand into broader precinct or commercial disputes beyond the original policy intent. We strongly welcome the government's decision to exempt airports handling fewer than 1 million passengers annually from mandatory participation in the Ombud scheme. This recognises the diversity of Australia's airports and removes unnecessary regulatory burden on smaller, regional and remote airports, many of which operate with very limited resources while still delivering services that are absolutely essential to their communities. We also welcome the federal budget commitment of funding to support implementation of the new aviation consumer protection framework. In summary, the AAA looks forward to continuing to work collaboratively with government, consumer groups and industry to help achieve that outcome. And myself and my senior colleague Natalie Hazelwood will look forward to your questions during that session.
Well, thank you very much, Mr Westaway. And now I'll come to you, Mr Charlton.
Great. Thank you, Chair, and thank you for the opportunity to appear before the committee. Our commitment to delivering positive passenger outcomes is long-standing and central to our role as Australia's largest airport. Airports obviously play an important enabling role in the passenger journey alongside airlines, the government agencies and other aviation stakeholders, with each responsible for different parts of that experience. Last year, more than 42 million passengers passed through Sydney Airport. And while the vast majority of those journeys were smooth, we recognise not every passenger has a positive experience, particularly when disruptions occur and passengers face frustration and uncertainty. That's why Sydney Airport supports the government's objective of strengthening protections for aviation consumers and establishing a framework which promotes accountability, transparency and improved outcomes across the sector. This was a key commitment in the Aviation White Paper, and we recognise the significant milestones the introduction of these bills represents. However, at the same time, it is important that the framework delivers meaningful, positive outcomes for passengers without creating unnecessary complexity, duplication or regulatory burden for the airports, airlines and other participants. It should provide clear lines of responsibilities and straightforward pathways for resolution with accountability aligned to operational control. Getting the balance right will be critical to the success of this framework. Now, we recognise that many of the detailed obligations and requirements of the framework will ultimately be determined through the regulation. reinforcing the importance of careful implementation across what is a very complex sector. Sydney Airport looks forward to continuing to work constructively with the government to shape a framework that again delivers clear, consistent and effective outcomes for passengers, and we look forward to answering the committee's questions.
Thank you, Mr. Charlton. You get some real wild weather up there, don't you?
We do from time to time.
Mr. Byron.
Thank you very much. Thank you to the committee for the invitation to appear. We welcome the opportunity to comment. It's important to state from the outset that Canberra Airport is supportive of measures that strengthen the protections for passengers. They have been inadequate. The challenges that they've faced, particularly in relation to cancellations, non-payment of refund, extraordinary delays and lost baggage, highlight why you do need an ombuds scheme. But it's got to be appropriately designed. We understand the importance of placing the needs of an airline passenger at the centre of the operating model. Each year we have 3 million airline passengers move through the Canberra Airport terminal, and we have consistently invested in delivering a safe, efficient and high-quality customer experience. This was reflected in April 26 this year when a report preparing for takeoff, surveying Australians' air travel behaviour and their attitudes showed Canberra Airport as the highest ranked airport in the country with a satisfaction score of 94%. The level of performance is not only reflected in the satisfaction but also in the limited number of complaints, and this is the key. Under the scheme, we're concerned about the funding model because of the nature and volume of complaints that we receive relative to what we're being asked to pay. Under the framework, the services delivered by us that would fall within the scope of the scheme are limited to paid car parking and airport accessibility services. Across these two areas, complaint volumes are low. In the last 3 years, since 2023, we've received 29 complaints relating to car parking and 3 relating to accessibility. Of the car parking, 8 of those relate to when our business set up a short-term car park in the city and used the same account name for car parking there. Not unreasonably, 8 people queried why they got charged for Canberra Airport parking when they weren't at the airport. We clarified it with them, valid charges. We had 5 people complain where they hadn't been given a receipt. We gave them a receipt. We have had a number of people complain about double charging of a credit card. We refunded those credit cards. We've had a number of people complain about fraud when a charge appears on their credit card for Canberra Airport. We never got the money, it had nothing to do with us. Anyone can do fraud and write it down as Canberra Airport. Nothing to do with us. You don't need a scheme for that. And lastly, one of our car parking complaints was from a member of Parliament where the airport boom gate let them out without charging them, and they wondered if we were giving them free car parking. I don't reckon you need the scheme for that one, sir. I'll take it on notice, isn't that what you say here? So all of these matters, and this is key, they were investigated and resolved directly by our staff without any following escalation. There's no external dispute resolution, wasn't needed then, isn't needed now. So we're not going to overload the system, I promise you that. And so let's look at the funding model. We think that you need to ensure the scheme is appropriately resourced, for sure, but the funding model doesn't appear to reflect the differing levels of regulatory demand, who's causing the problem, across the group of regulated entities. In our case, we've got a small number of complaints and we've been able to resolve them. So why do we get an annual levy imposed on us when, in reality, we don't need it? It wouldn't be appropriate, to, in our view, respectfully, to expect well-performing, low complaint-generating, already regulated entities to fund the operation of the scheme, and the oversight doesn't necessitate our behaviour and hasn't necessitated the commencement of the scheme. In reality, we didn't cancel any flights, we didn't refuse to pay refunds, and we weren't losing the baggage. It was airlines, and this is for airline passengers to protect them. So a more balanced approach, we feel, would work this way. Airlines would contribute through their annual levy in proportionate to their passenger volumes. Pretty reasonable, their complaints. While airports could contribute on a basis per complaint, because I don't reckon you're going to get that many escalated beyond airports. But we'll pay on a user pays basis. We'll sign up for that. My last comments in relation to opening involve 2 other significant issues in the bill. The first is the definition of airport service, which does expand it beyond paying passengers to include non-travellers, meeters and greeters. Now, we actually don't get any complaints from them, but we don't have a contract with them, we don't charge them, we don't do anything. I don't really think they need to be front and centre of a scheme. They just expand scope for no regulatory reason. Likewise, the definition of airport accessibility service includes non-passenger risks, which blurs the scope of the scheme again and shifts it towards broader public access issues rather than specific accessibility matters. And I'll just comment on our accessibility matters. We've had 2 complaints, very reasonable, inquiring about the need for where a service dog might go to the toilet before a flight. We've dealt with those, and we'll deal with them more as Virgin brings in dogs for travellers. The last one was the first complaint we've had in 28 years of running the airport, because today we took over running the airport from the Commonwealth Government 28 years ago today. We've had 1 complaint about the disabled car parking, and it was about the size of the spaces. We checked it and it was compliant. Don't reckon you need a scheme for that.
Well, on that, thank you very much for those opening statements. Senator Cadell.
Thank you. So what the airports are saying, I'm paraphrasing, so your chance to beat me up for being wrong, this should be about a genuine consumer relationship, not anyone that uses our facilities relationship. Is that what we're saying?
We're saying that the relationship here would be where the operational control is, because where you start blurring the lines and accountability, because there's lots of service providers at the airport. Yep. So if the consumer baggage gets lost, is it the baggage handler or is it the airlines? If the meal is not prepared the way they've requested in advance, is it the caterer? Then you start blurring the lines of who has operational control. So to Stephen's point, if it was dealing with the car park where we have a commercial operational relationship with the consumer, then absolutely. But we don't have the operational relationship with the consumer. We do have relationships with the airlines where we enter in agreements with the airlines, and part of those agreements is how we provide service to the airlines. There is a commercial relationship with the airlines. We can deal with some of these issues between us, but we're saying where operational control is where the consumer has a relationship.
Of course, if you stretch this out in its length, we had Air Services estimates last week. If Air Services can't maintain a control tower and they cancel the flight, wouldn't they be the ones on the hook? If you're extending this out, the government would be on the hook for cancellation of flights?
Well, we believe that the government agencies should be considered as part of the scheme, not part of the compensation, obviously, because they're not a regulated body like that. We believe they should be taken in as part of the scheme, so the consideration of how they impact the airlines, how they impact the passengers, and how we report and provide transparency, it would be good to have that as all part of the scheme, so that there is an issue with Air Services, or if there is a security issue or border force, that it's all taken into account when it impacts the consumer.
Yeah. Mr. Byron, you raise an interesting point about the funding and the proportionality of the funding versus where it is. If we would go to a model that was, in a sense, I see your argument is this cross-subsidisation by the good operators for the bad operators under this model where everyone pays a fee on volume rather than issues. If we want to go to a number of complaints for airports, why wouldn't we do that for airlines as well? If there's one airline doing particularly well and one airline doing particularly bad, why wouldn't we extend that there?
Good idea. I think it makes sense.
I think, Senator, we all believe it should be proportional or some variable component. So you are incentivize people to resolve the complaints before they get to the scheme. For Sydney Airport, we have quite a bit more complaints, but in the end, we have unresolved complaints, about 3 to 5 a year, unresolved complaints that go through our system that end up somewhere else. So again, we think there should be a variable component so that you are incentivizing those people who do deal with their customers before it gets to the outcomes.
Mr. Westaway, you said in your opening statement you welcome the 1 million pax per annum differentiation. Obviously, we're all part of a regional aviation inquiry at the moment. We're hearing sort of lack of access to some sort of loading facilities and different things. Why is that so important on thin airlines that we maintain that?
I think it's really important, Senator, and we welcome the government's desire for this to be in place. Firstly, this will be the first time globally with such a scheme that airports have been part of it. And Australia similarly has a very unique aviation system. We have a number of very big, large, growing airports. We have a number of emerging regional airports. We have 14 airports around the country that currently carry more than 1 million passengers a year. But as part of my opening statement, we have around 340 airports, which means that the vast bulk of airports carry a lot less than 1 million passengers per year. So our view is, and none of the senators be well aware of the disparity between the cities and the regions and their remote parts of the country. is this is a regulatory burden, and the regional airports and remote airports are not the problem here. So our view is, and we're supportive of the scheme as my colleagues have outlined, and what we would love to see is the ability to have this phased approach, and we believe that's the right way to go forward. Around 93% of flyers fly through these airports with more than 1 million passengers a year, so we're really trying to put a sledgehammer on a walnut if we were to look at wider airports beyond those.
Okay, so I think clear evidence, we clearly understand. I'm having trouble coming up with the basic point, if I go over it, is keep the designation of airports, move to proportionality, and move it only to where the consumer relationship exists in this scheme. Would that be the 3 key points we're saying? I'm not missing much?
That's pretty much it. Yes.
I don't think you miss. It's a nice summary, Senator.
Okay. I have no more given that. I'm going to...
Well done. I was just thinking...
Thanks for your reading.
Sorry, I've got to take Mr Byron's opening statement. I was listening intently to all of you. But I think it's a bit unfair, Mr Byron, that you are so quick out here because you want to get rid of all the pollies and all the staff. You don't have to answer.
I mean, we did try to design the airport in a way where one of the key things was you could get to the airport quickly, you could get rid of your car or get dumped out of your car quickly and get through quickly and leave quickly. For us, we're competing with particularly Canberra-Sydney and speed and reliability. And people who, particularly business people, do want to just get through and get on. So minimising that time, it's not for us about tricking you into shopping or that sort of thing. But yeah, we did, and we said the bias needs to be on getting people onto the flight quickly. We have a philosophy that every minute matters, and we're all here to help to get you on that plane on time.
As someone who's been known to pick up people from your drop-down area, I'm not going to go too far.
You didn't have to bite, but I just had to have that throwaway line. But Senator Cadet.
Just one question. You're talking about your complaints rate. Would you know the number of cancellations or complaints that are generated by cancellations by air services versus?
It's very difficult because some of there's weather, there's what's happening. I mean, we know from last year in their own public report, there were 17 days which were affected by staffing issues.
Yeah.
So how the airlines then treat the cancellation, that's really up to them for what reasons and the slots. So those are all operational decisions that are then made by the airlines.
Okay. Thank you.
Thanks, Senator. So I just one very quick one before I go to Senator Mulholland. And I was talking to someone yesterday, I'll put my question to you, Mr. Westerway, but it's to all of you. This was a Qantas flight into Perth yesterday, landed on time, or around the expected time, then sat on the tarmac for over an hour and nearly an hour and a half, I believe, but I'll be challenged if it was that long. That was certainly well over an hour, because they couldn't get the air bridge working. And then the first technician or mechanic couldn't fix it, so then they had to wait for a second one who was allegedly 10 minutes away and rocked up half an hour later. Now, I believe the feeling within the plane was everyone was looking for someone to choke. I'm not allowed to say that in this committee, am I?
Yeah,
No, I better take that back, sorry. They were very frustrated. Whose fault would that be? Now, I know it was Perth Airport, but I just put it out widely.
No, it's okay. Perth are a really strong member of ours. I've been doing a lot of work with them over here this week. It's a good question, and there's a contractual relationship between airline and airport with respect to the aerobridge infrastructure as part of the arrangements that they have in place. So that would have to be worked through in terms of if there was a fault on which part. But I mean, the airline operators usually operate the aerobridges. Perhaps Scott can add a little bit to that from how it works in Sydney, but ultimately it's on a user arrangement with respect to the aerobridge. But I haven't been briefed on that particular flight delay.
Yeah, no, I understand people don't want to slap Perth around. Crikey, that's my hometown. But there was suggestions why couldn't the plane be pushed back and then stairs put in place. And the captain himself, I believe, was on the airline, was on the UHF, saying he's never experienced this before in 20 years of flying. So just had to raise that one because I reckon people would have been prickly after it was a flight from Adelaide.
Yeah, from time to time, obviously there's operational maintenance issues. They're few and far between. We have a contractual relationship with the airlines. But I think as well there's a lot of operational decisions that will get made, and we have decisions where planes land early or planes land late, and we say to them, we can bus you, but the pilot may say, no, we would like to wait for a gate, so they may decide to wait on the tarmac for 30 minutes or whatever, waiting for a gate to clear. So there's all kinds of operational decisions that get made around that. You can't push back and do rear stair loading because the planes could become disbalanced if they load from the back. So these are all the issues that get very complicated and then start muddying the waters, as I said, with who's got operational control and where's the relationship sit.
And it wasn't Sydney and it wasn't Canberra, so you're okay, guys. And I just will say one last thing, that myself and Senator Colbeck, who's just outside at the moment and be back in a minute, we remember the old Canberra airport. So congratulations, Mr Byron. This is a magnificent piece of infrastructure. As is Sydney. There you go. Senator Mulholland.
Thank you for that, Chair. And at Brisbane Airport, more often than not, we're bussed into the terminal, so they make us work for it in Brisbane. No aero bridges for us. So anyway, what I would like to do is go to some of the concerns that have been raised about who should be responsible for conduct under the Charter and where that sort of lays. And I know that we've got a bit of evidence here that from the AAA's perspective that airlines have a lot more control over the drivers of operational decisions that cause the most challenges around delays and cancellations. But I think, as we've heard an example from the Chair, if there's a case of an aero bridge breakdown, we had a case the other day at, I think it was Canberra Airport, where there was an issue with the belt, with the baggage system, and that put impact onto then security lineups and then impacts onto flights as well. So, would you not agree that there is a shared responsibility between airports and airlines, and that from a consumer perspective, they don't really differentiate between the left hand and the right hand? It's all one end-to-end consumer experience. And if we were trying to break that out into a charter, we would have challenges.
Perhaps, Senator, great question. Perhaps I'll have a shot from the AAA's perspective for the broader airports, and obviously Scott and Stephen can add in, or Natalie, indeed. Look, I think the issue is you've got to look at what the overarching issues are. I mean, there's two buckets that have well over 2/3 of complaints. And by the way, we're moving the best part of over 200 million passenger trips a year into and out of this country, and a little bit more, the majority of those are in the domestic and regional space. So there's a lot of people movements. We have a great system. But the reality is, 46% of complaints relate around things like flight delays, cancellations, changed itineraries. And in essence, another quarter relate to baggage complaints, which have nothing to do with an airport infrastructure. They have to do with the management of the bag. So I think you've got to sort of look at it more holistically. Obviously, an area like car parking, if there was some complaints, and what Stephen alluded to before, the airports look in on that. We're very, very, very granular in terms if there is a complaint made against the airport or the infrastructure, we look into what the reasons for that are. So I think we've got to look at it more holistically. That would be my answer to that.
But I think, Senator, from our point of view, we have airline relationships where we offer certain service levels to our airline partners, which includes IT infrastructure, which includes certain baggage makeup times, so affecting the baggage system, security times, other things like that we provide under certain of our arrangements with certain airlines. So in effect, if we don't meet those obligations, then the airline pays reduced charges to us. So if there was an impact to their passengers, they effectively, there would be a reduced charge to us, then there is a commercial arrangement between the two that would help defray that. But again, it would, as you said, muddy the waters by who's responsible for each part of the system.
And if I could add too, I mean, the aero bridge is the absolute classic example, and we as an airport are responsible for the piece of infrastructure, and our contractual relationship is to the party that we're providing it to the airline, and they're there representing their passengers. But it's really, really clear in responsibility. And if it doesn't work, they can beat us up and we want it fixed. I mean, it is all shared, but the clarity of the contractual relationship is really key. What was interesting is when we first opened the new airport and we had the new aero bridges, it was really slow. I don't know if any of you parliamentarians can remember it, but rather than taking 1 or 2 minutes to get the aerobridge onto the gate, it would take 8 or 10 minutes. It'd drive you nuts. You know, a little delay that's not normal and is worse than normal was really bad. Now, the truth was, in Qantas's case, they were then Qantas staff members who were being trained and getting used to the new system, but it took like 2.5 months. In Virgin's case, they were an outsourced company providing baggage services, but the chain of contractual command meant that we could in turn address it with each party, double the training, double the effort, you know, all fret about the pain to the passenger and all work together to get it fixed. It wasn't the aerobridge not working, it was the training. Anyway, I mean, it is that chain of command and it does generally work.
I'm on link, my legs and my aerobridge.
Yeah.
And Pelican?
Yes.
Thank you for that. You know, I think, you know, I do think from a customer perspective that, you know, yes, you might be the airlines might be getting a number of those delays, but whether or not that data is breaking down into the causes of those delays is, you know, I'm not across that data. And I think that's something that would probably warrant further consideration about, again, from that shared responsibility perspective. End of the day, they might be complaining to the airline they got delayed, but there could be reasons, aerobridges, baggage systems, etc. I do also just want to preface all of that with saying I have remarkable respect for all of our aviation, baggage handlers, crews. They do an incredible job, and I think they've gone through a really, really tough period through COVID. With lots of frayed tensions, people having really tough days. And I just want to acknowledge what a tough time it's been for the industry and the workforce, and everyone's doing a remarkable job under very, very tough circumstances. One of the things I just wanted to quickly touch on, from an earlier perspective, we had the Justice and Equity Centre, and they were focusing particularly around the experience of disabled passengers moving through airports and onto planes. I think it's the AAA submission. You identified some concerns around airports being held responsible for matters a bit outside of their control. Do you accept that there is some accessibility obligations and assistance requirements, particularly for passengers with disability, where airports can play an important role alongside airlines in providing access and making sure that there's a really strong consumer experience?
Thanks, Senator. It's a great question. I'm going to hand across to Ms Hazelwood, who's our policy expert in this area, because I think it's a very, very good question.
Thank you, Senator. So at the AAA, we represent airports across the country, as we've already outlined, and our airports are passionate about delivering exceptional services to the customers that journey through the airports. And we have done an audit recently, and there's over 140 different programs that airports carry out in order to enhance the customer experience. Our organisation also runs a customer experience committee that has representatives from across Australian airports and New Zealand airports, where the focus is on delivering the best outcome for passengers. But something that we're really concerned in with our submission is really how the different accessibility legislation will work, and we think there's need for greater clarity, because at the moment we know the department is developing an aviation-specific accessibility standards, and we're concerned that there could be potential overlap with existing standards, and obviously the charter and the legislation is being developed at the moment, so we just want to make sure that there's the appropriate clarity so they all work together seamlessly.
Thank you for that. And my last questions go to, in your opening remarks, Mr Westaway, you talked about about regional airports. You've got some great regional airports around the country. They're doing significant work in moving a lot of our constituents around the country to get to medical appointments, simply get to work, or to get to important events. We also know that the regional airports are really running on the smell of an oily rag as well, and those airlines are as well. So welcome just some final comments from you around the government's approach to excluding small regional airports from the scheme.
Well, we think the government is really understanding and is in lockstep with the aviation sector and what we're trying to achieve here. I mean, it goes from those commitments that were made around Rex Airlines through to what we're talking about here today. I mean, we did some strategic research with ACL Allen, the very respected research house, and collaborated with Regional Capitals Australia, which is the, if you like, the head lobby organisation for the regional cities around the country that, and they all have airports, so airports is a key part of it. Over 70% of regional and remote airfields continue to have a significant operational loss, at least $500,000 in terms of a median annual loss. So let me repeat that, $500,000. Now, these airports, in essence, the capital requirements and their OPEX requirements are through the ratepayers. We've got a really significant issue in this country, quite frankly, probably beyond this forum today, which is why the Productivity Commission is currently looking into this very matter around the determinants of regional airfares and the broader aviation challenges that are there. So we really support what the government's trying to do here, because they really understand what's occurring, that we really do have to look at the regional and remote aviation sector somewhat differently to how we look at it from our broader capital city gateways, which are critical to our country and obviously are major hubs for a number of these regional communities that connect through.
For that. And I know I said that was going to be my last question, but I did want to just sneak one in, sorry, Chair, to, I think it was Sydney Airport. Your submission talked about wanting to include some entities like Border Force and Air Services into the framework as well. I talked a little bit about this to one of the earlier witnesses about the challenges that may present from a regulatory perspective, from a law-keeping perspective, if we're trying to bring those functions into a consumer-facing standards and framework. So, you know, my concern is that there's a fundamental difference between consumer passenger services and government functions like Border Force and Air Services when it comes to border control and air traffic management. So I'd welcome just your thoughts in that space.
No, thank you, Senator. I think what we're saying is, again, not necessarily under the regulatory framework, but when the ombudsman or the framework is considering the outcomes of the complaints, that the understanding of Air Services and Border Force and the impact on the airlines and the network is all taken into account, so that you have the data, you have the references, because it is a very complex system, and it may relate to Air Services, it may relate to Border Force, which they have their own reasons, and security and other reasons are obviously paramount. But we just think it's important that the ombudsman and the scheme take into account the impact that those agencies have on the airlines, so that they can look at the whole picture.
Thank you. Thank you very much for that. And I'll hand back to you, Chair.
Thanks, Senator Molan. Mr. Byron, did you wish to add something?
Yeah, thank you, Chair. Just to the Senator's question on accessibility, my colleague Michael Thompson had some material to just expand out, if that's all right, please.
Thompson.
Senator, thanks for the question about accessibility. It's certainly one of those things that we focus on, and we're very keen to make sure that the passenger journey is as seamless as possible. People with disability, and particularly people with hidden disabilities, sometimes find the experience challenging. And so we've done a lot of work in that area. We have sensory maps on our websites. We have the Sunflower scheme as well, which is available, which is a great way of someone with a hidden disability being recognised with that disability to make the transfer easily. And then we do a lot of training for our staff and also our security. So we'll invite various disability groups such as Spinal Cord Australia, Disability Australia, to come in and educate our staff and our security staff about how to handle some of these challenges. So it is something that is really a focus for us, and I think the recent 94% satisfaction level probably highlights the focus we are putting on that area.
Sounds great. What's the Sunflower?
It's a scheme whereby if someone has a disability or a hidden disability, and they want to be recognised as they're going through the process, but without over-the-top recognition. It's a little lanyard or a pin, and it's recognised by airline staff, by our staff and by security staff to make, I guess, the journey a little less confronting.
Brilliant.
And Chair, without taking Canberra Centre, I think that's consistent with all of 5 major airports that have implemented most all of these scheme, which is why, again, we want to see that the airlines and the airports and the people doing the right thing are incentivized to do the right thing and not punished just flat across the scheme based on passenger numbers, but more where the variability of complaints is.
Very good, very good. That's great. Mr. Westaway, pass it on to the others who aren't here, mate. That's magnificent.
Oh, we do it for a lot of, it's a great question, Chair. We do that, many of our airports are into that scheme, and that's a recognition piece, right around the country, and there's a lot of people now travelling with levels of disability. Obviously, we have an aged society as well, and it's going extremely well, and we partner very well with the provider.
Yeah, that's good to hear. So there's some good news. There's a lot of good news around. Fantastic. If there's no further questions, look, can I thank you very much, all of you, for making the effort today. We appreciate that. Mr. Byron, if our planes are 1 minute late today, we'd be banging on your door after that. All right? So you better check which flights we're all on. Okay, thanks very much.
Thank you.
Take care, everyone. Now, we are going to a scheduled break for 15 minutes, I think it was, 20 minutes. 20 minutes today, stretch the legs. We were scheduled to come back at 11:30, and we'll still come back at 11:30. Sound good? Okay. Thanks, everyone. I now welcome Professor Samuel. Where is he? Oh, there you are on video conference. Okay, thank you. Professor Samuel and Mr. Beckett from Airlines for Australia and New Zealand. Mr. Pearce from the Board of Airline Representatives of Australia. Thank you. Mr. Svensson and Ms. Tully from the Qantas Group. Good to see you again. And representatives from Virgin. Right, hello Virgin. Okay, so I understand the information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you. And for the Hansard record, would you please state your full names and the capacity in which you appear today? And I'll start to make it easier for all of us up here with the list that I have. So in other words, what's easier for me? Professor Samuel.
Yes, Professor Graham Samuel, Chair of Airlines for Australia and New Zealand. And Chair, could I sincerely apologise for not being there present in person? I think as some will be aware, I've just had knee replacement surgery and I wasn't allowed to travel. I should preemptively warn you that if I do wince through the proceedings, it will not be as a result of the discomfort with a question. It's more likely to be the pain meds wearing off.
Oh, you don't know yet, mate.
The day is early.
Just warming up.
The day is early.
Well, you've set the scene for other excuses today. No, but that's fair enough. Professor Samuel, as always, good to see you, and I know that you would be here if you could be. Thank you. Mr. Beckett?
Yes, thank you. I've submitted the paperwork, thank you.
No, just tell us who you are.
Oh, sorry, Stephen Beckett, Airlines for Australia and New Zealand, CEO. Yes, thank you. CEO of Airlines for Australia and New Zealand.
Thank you. Mr. Pearce?
Yeah, Mr. Stephen Pearce, Executive Director of the Board of Airline Representatives of Australia.
And you're here on your own? You're the only one today?
I'm here on my own.
That's good. No worries. Mr. Svensson and Ms. Tully?
Yeah, Marcus Svensson, CEO of Qantas Domestic.
Steph Tully, CEO of the Jetstar Group.
Thank you. And our representatives from Virgin?
Andrew Cleary, Chief Customer Officer.
Alistair Hartley, Chief Transformation and Strategy Officer.
Rebecca Walker, General Manager of Legal.
Ali Dunn, General Manager, Product and Customer Strategy.
Great, welcome everyone. So I understand that information, and I think I've told you all that, and I've done that. Okay, yes, Senator Cadell.
For the record, I am the recipient of both a Chairman's Lounge and a Beyond Lounge membership of the witnesses.
Yeah, so am I.
So am I.
Okay, that's fine, thank you very much. Now, if you'd like to make a brief opening statement, I'll start with you, Professor Samuel.
No, I'll pass over to Stephen Beckett.
I'll make it.
There you go, Mr. Beckett.
Thank you, Chair, and I'll make some opening remarks on behalf of A4ANZ, the Qantas Group and Virgin. A4ANZ supports the intent of this legislation and we're committed to working with the Parliament to ensure that the aviation consumer framework is fit for purpose and it's a success. Passengers deserve to know what they're entitled to when things go wrong, and they deserve a fair, accessible way to resolve it if an airline, airport, travel agent, government agency or so on doesn't deliver. We're not here to argue against any of that. Done well and covering all relevant industry participants, this can be good for passengers and good for the industry. Coupled with strong consumer protections under Australian consumer law, which are widely regarded as the gold standard globally, it can help passengers understand their rights and provide a fair, accessible way to resolve disputes when things go wrong. But the model before the committee has real flaws. If not fixed, this framework risks making things worse for the very Australians it's meant to protect. This is a one-size-fits-all imported model from overseas, designed around a premium full-service airline. But of course, the Australian market is very different. We have full-service, low-cost, value and regional carriers serving vast distances and many thin or marginal routes. If Parliament ignores this reality, these new laws will inject millions of dollars in cost overnight, and unfortunately, customers will pay for it in higher airfares. The broader implications for Australia are clear, and this is underscored by the letter sent to the committee on the 21st of April, co-signed by the CEOs and leaders of businesses and tourism sector. A4ANZ is also aware of alternative proposals to go even further than what's proposed by the government and to introduce a mandatory compensation scheme to Australia. In Europe and Canada, these models have driven up airfares, imposed particular pressures on low-cost and value carriers, and added significant strain to thin and marginal routes. In Canada, multiple low-cost carriers exited the market, in part because of the cost burden associated with a mandatory compensation scheme. Mandatory compensation schemes do not automatically translate into better performance, as the root causes of disruption, including engineering faults, bird strikes, airport failures, weather, staff sickness and air traffic control, are not solved by a financial penalties regime. For Australia, the alternative proposal could jeopardise the low-cost airline model and reduce connections on thin, mostly regional routes, while diminishing choice and competition for consumers. Should senators wish, we'd be happy to elaborate on these impacts during the question time. But in terms of the proposal in front of us, we have four main concerns. 1, safety must be paramount. 2, all relevant aviation participants need to be included in the scheme, not just airlines. 3, poorly targeted, over-prescriptive or duplicative regulation means more cost for consumers, less choice and less competition. And 4, more cost puts regional services particularly at risk. On the issue of safety, safety is the foundation of aviation and it must be explicit in the bill and the charter. It's not enough to assume it. Safety-based operational decisions should never be second-guessed through a consumer framework. The concerns here are also shared by pilots and the Pilots Association. Second, aviation is a team sport. Disruption is not caused by airlines alone. It can be caused by air traffic control, airport failures, security screening issues, weather or errors made by travel agents. If the framework does not cover the relevant industry participants, accountability is distorted and consumers will be left to fall through the cracks. Third, cost. More regulation, duplication and conflict with existing laws, and we heard from the Disability Commissioner a little earlier about that being her biggest concern, means more complexity, confusion and cost. And that puts direct pressure on the price of an airfare. This year alone, airlines are carrying higher fuel prices, higher airport charges, higher air service charges, a higher passenger movement charge announced in the budget, a higher security and compliance cost, and further changes in the area of sustainability are yet to come. Each measure may look modest on its own, but together they drive up the cost of flying and put marginal routes at risk. And what is most concerning is there's no joined-up view across government. Departments and agencies are acting in silos with no proper assessment of the cumulative regulatory cost or impact on consumers. It's also important to recognise Australia's existing consumer laws are widely regarded as the global benchmark. ACL is fit for purpose and is enforced by the ACCC and supported by state and territory agencies. The answer is to build on a framework, not duplicate it with costly overlap and added complexity. Any new model should avoid conflict with established international aviation law, including the Montreal Convention framework. Regional connectivity, rising costs do not hit every route equally. They hit thin routes first, and they are often regional, rural or remote, and they hit those communities particularly hard. These services run on very fine margins, but are essential for jobs, healthcare, tourism, freight and social connection. We've already seen services recently suspended or reduced when cost pressures bite, including in Wollongong, Mount Gambier, Coffs Harbour, Devonport, Burnie, King Island, Cairns, Uluru, Alice Springs and Darwin, just to mention a few. If the new regulatory costs are layered without care, more communities will be exposed. Air travel in Australia must not become something that only the well-heeled can afford. And context matters. The industry knows performance after COVID was not where it needed to be, and many of the earlier speakers today specifically reflected on the time post-COVID. We know that consumers were frustrated, and rightly so, but the sector has improved dramatically since then, and that matters when deciding what is proportionate today. On-time performance has improved, and last month Australian Airlines were among the most on-time airlines in the world. Cancellations are down. The year leading to April, the year 22, 11% cancellations compared to the year leading up to April of this year, down to 2.3%.
Complaints handling and customer communication have greatly improved. The improvement reflects investment in fleet renewal, engineering coverage, operational resilience and better engagement with customers, including during disruption. Our member airlines are making some of the largest fleet investments in our history, and that is exactly why cost discipline matters. These investments deliver real customer benefits, including better reliability, better customer experience, better operational resilience, better sustainability, and you're more likely to see better restoration and expansion of future routes. The industry has improved materially, so it's vital these reforms should respond to today's conditions, not earlier frustrations. In conclusion, our ask is simple. Support an ombud scheme, but do not lock in a flawed model. Make safety explicit, cover all relevant participants in the aviation system, avoid duplication when existing consumer law and without conflict to international aviation law, and properly assess the total costs before the framework is finalised. What customers want to know when a flight is delayed is quite straightforward. Tell me what's happening, give me the options, and if you've genuinely got it wrong, make it right. A clear minimum standard framework can deliver, and without requiring a highly prescriptive regulatory manual that airline teams and customers can't readily understand or apply at a terminal gate. Australians deserve strong passenger rights, but they also deserve affordable aviation. If we get this right, we can protect consumers without pricing them out of the market. Thank you.
Thanks, Mr Beckett. Now, Mr Pearce, you wish to make
yes.
an opening statement?
Thank you, Chair. I'd like to read a brief statement, not as long as my colleague, echoing a few of those points. Barra focuses on the practical operational needs of over 40 international airlines operating to Australia. And those Barra members collectively provide around 60% of the total international capacity operated to and from Australia. And the focus of those airlines is more, therefore, looking into Australia than perhaps from the Australia base, and our remarks are made in that, on that basis. We also support the intent of the Aviation Consumer Ombud Scheme, if done right. We agree that passengers deserve to know what they're entitled to when something goes wrong and to receive the due care and service if that occurs. However, intent is not the same as execution, and getting the details right is critical, as over-prescriptive requirements can result in unintended consequences, limiting the ability of airlines to provide the best customer outcome. Barra considers the new scheme therefore needs to be proportionate, practical and affordable if it's to achieve the right outcomes, and certainly improving communications and awareness for passengers is crucial to reaching those better outcomes. Very briefly, in terms of proportionality, most international airline passengers are satisfied with their air travel today, and international aviation to and from Australia is highly competitive. International airlines compete on service, and this already includes the provision of customer care and services when disruptions and delays do occur. International aviation involves multiple stakeholders and many important contributors, including air traffic control, security screening or travel agents, for example, all of whom can have significant impacts on these delays or disruptions. All communications are currently not included in the scheme. And so to effectively reduce the impacts of delays and disruptions, all stakeholders should be included. In terms of practicality, safety is paramount for all airlines, and safe operational decisions must not be compromised by scheme rules. Operational flexibility to respond to ever-changing, on-the-day circumstances is critical to enable airlines to operate safely and efficiently and get passengers to their destinations on time or as quickly as possible if there is a delay. Overly prescriptive service remedies with strict delivery timetables can ultimately compromise an airline's ability to deliver the best possible outcome when responding to delays or disruptions. And finally, affordability. International aviation is highly competitive and consumers are extremely sensitive to airfare costs. The cost impost from similar consumer protection schemes overseas, likewise all introduced with good intentions, have ballooned, and these costs simply result in higher airfares than would have otherwise been available. In conclusion, Borough's international airline members provide a wide range of aviation options for travellers and are an important contributor to Australia's economy. Increasing complexity and cost to operate may risk the positive growth rates to date of international aviation services to Australia. Australia has the opportunity to avoid the unintended consequences of similar schemes introduced overseas. However, to achieve this outcome requires more careful crafting to balance the needs for proportionality, practicality and affordability for consumers and industry alike. Thank you, Chair.
Thanks, Mr Pearce. Before I go to Senator De Liga, I just want to make a couple of statements more than anything else. And I speak only for myself, not for the rest of the committee. But someone who is privileged enough to enjoy the comfortable part of flying, I'm really appreciative. But guys and girls, when you cancel planes, I've got to tell you, the stress you put on people is huge. And when I walk through the terminals and there's a mother with 3 children, one's crawling on the ground, another one's trying to punch up the other one or whatever's going on, they don't get the same information as we get. I have to stress to you, you come here all the time, and I'm supportive of you, but you come here all the time saying things are getting better, it's on the improve. Well, it might be for Glenn Still sitting in the chairman's or the Velocity, yeah, but for the poor bugger out there with the screaming kids, it ain't. You're fooling yourselves. I have to just clarify that. I'm very happy to hear that you want to work with the government. I'm very happy to hear that you have a responsibility. I know the challenges you have, and I just said to the Sydney Airport reps earlier on, particularly Sydney with weather, that's not your fault, I get all that. But when you start talking about regional and remote, this same committee happens to be doing an inquiry. Trust me, gang, you're not loved out there. Okay, you're not loved everywhere you go. And I will say this because I'm on the record. You lot, I love you lot when we go to Kununurra. Great, what a fantastic job you do. You lot, Christ almighty, you got your finger in the pie with your relationship with Air North when you can be $1,200 or $1,300 dearer than them. So don't fool yourselves. There's not a dry eye up here for the crocodile tears. But we want to work with you. Okay, we enjoy being on your airplanes and we want to be safe. Mr Beckett, you know my history, mate. Okay, safety number 1. I just have to clear that. Really keen to hear what you've got to say. The airports have already come out and said they have their responsibilities, and it's security and car parking, but they're not responsible for the baggage handling. They're not responsible for the catering stuff-ups. So let's start on a real good footing and let's see how we can take this forward. Mr Beckett.
Thanks, Senator. If I can just reflect on that, and we do want to work, as I said, it is a team sport. In terms of the airports, we want to work with them, but when their infrastructure breaks down, like the baggage handling system, and our baggage handlers can't load a plane, or the dual high fuelling system, their infrastructure breaks down at Perth Airport and 64 flights are cancelled, they do have a responsibility and have skin in the game. So it's a team sport, and I look forward to us all working together.
You are spot on, and the amount of times I hear that there's a mechanic coming or an engineer coming in, we know, the poor devil in the terminal doesn't even know what's going on half the time. Anyway.
Just with respect to your comments.
Oh, I'm not in trouble again, am I?
Yeah, well,
I think it's going to reinforce it.
It might reinforce what you just said. So this came into my inbox at 11:28 this morning.
You started talking.
11:28 this morning. We are sorry, your upcoming flight, QF to Melbourne on Friday the 29th of May, has been cancelled. This is due to operational requirements. So
come on Virgin with me, mate, today.
This afternoon.
Yeah, I'm going to Tasmania to Devonport, and none of the rest of you are an option to my port. And I'm not getting home till tomorrow now instead of tonight. So crocodile tears don't work here either. I'm sorry.
All right.
Chair, I'm wincing, and it's got nothing to do with pain meds wearing off.
Oh, all right, that's fair enough. Okay, I'm sorry about that, Mr. Sarah, it didn't help. But on that, let's have a real productive conversation going forward, and we'll treat each other with the greatest of respect because we want to fix this. Senator De Liga.
As always, Chair, and I'm sure we all echo your very, very fantastic words. And again, it is we're all here for the sake of making the air travel better for consumers. I do want to start asking a couple of questions, or a block of questions to Virgin, and I was hoping that that Mr. Bennett was going to be here today because I'd like to just to talk about a LinkedIn post he made about a personal experience with Airbnb cancellations. He described the experience as stressful, unreliable, and something that caused significant disruptions for an important family event. And a quote was, your business used to be a reliable source for cost-effective, pleasant accommodation and is now a bad gamble at best and mercenary at worst. We have many more bookings to make and we will not be using Airbnb for any of them. We will go back to hotels where we have never had the issue. Another quote, these hosts should be penalised and should be ashamed of the notable drop in your services and appeal. Now, did this experience give Virgin a greater appreciation for how airline passengers feel when flights are cancelled or changed with limited alternatives available?
Senator, I can take that. It didn't. We live and breathe airline, like customer complaints, customer feedback every single day. These processes are ingrained in how an airline operates. And what we listen to are the statistics, the complaints, the feedback of our customers. We listen, you learn, and often you have to adapt. What Christian's done there is a personal post on a social media channel. We're here to talk about Virgin Australia's response.
But Mr. Cleary, we're also talking about an expectation of a level of service, and as an executive in an airline, I find it quite... I think it's great that he's made the post, but I also think that probably people in glass houses shouldn't throw stones. Would you agree?
I'd say it's feedback for Christian. He was commenting in a personal capacity. We do have a company, LinkedIn, but I also want to stress this is social media. LinkedIn is Instagram for professionals.
And absolutely
they talk about
social media,
work.
but LinkedIn is more of a professional platform linked to Virgin. He's got his title on there. He's got everything to associate with Virgin. Yeah. In the post, he argues that that hosts who cancel their bookings should face penalties. So why should the accommodation providers face enforceable consequences for cancellations, but airlines not face stronger enforceable passenger protections?
Yeah, Senator, very happy to answer the question about airlines. Just want to be clear though, Christian's comments in a personal capacity don't represent our views. And the comments that he was making on LinkedIn are his personal views in a social media environment. But back to your question, because it is important, why shouldn't there essentially be a pay for delay scheme? That's the question that you're getting at. I'm actually going to ask my colleague Rebecca, our GM of Legal, to take that question.
Thank you, Andy. We have submitted through the various consultation processes that we don't think a fixed compensation scheme or like a pay on delay scheme is the right approach in the Australian context. We have been working collaboratively with the department and the interim ombuds to share our views on this. We recognise their efforts to look at all the models that are available, including in the international context, but we don't believe that pay on delay delivers the right outcomes for consumers. Two probably key points that I'd make there. The big pay on delay schemes that are currently in place are the EU 261 model and then the Canadian model as well. And what we've seen in both of those jurisdictions are a significantly increased cost to airlines. I think that if you've read the IATA submission onto the pay on delay bill, there's some really interesting information in there about the cost to airlines. In the EU, a 2020 report completed by the EU Commission found that the cost to airlines of EU 261 was around $8.9 billion in 2018. Not quite as much in Canada, but studies have shown that in 2023, cost to airlines for their pay on delay scheme was around the $340 million mark. Our view also is that a fixed compensation model doesn't accurately reflect the loss that consumers might suffer as a result of disruptions. When we talk about compensation, it is based on a measure of loss. In some cases, fixed compensation can overcompensate customers, and in other circumstances, it may actually undercompensate customers compared with what they might be entitled to under the existing consumer protections regime.
So, and I know, Mr. Cleary, that Virgin considers Mr Bennett's post in a personal capacity, but I want to just go back to that feeling of powerlessness when disruptions do occur for consumers, and especially when they're close to those important events. Do you guys accept that people do feel and consumers do feel powerless when they are dealing with airlines, when their flights are cancelled, and particularly in regional markets? I mean, Senator Colbeck just gave another example just this morning of another example, and where especially where our options are limited. So do you accept that consumers are powerless and they feel powerless when dealing with you guys?
Yeah, Senator, the question around do you accept that consumers feel powerless, frustrated, angry, all of these things? Absolutely. Just like everyone here today, we're also passengers, but we live and breathe the realities of how we look after customers every day, and we genuinely care about it. When you go back to, and this was really important in the opening remarks, 4 or 5 years ago, the context that we're all sitting here today, the industry performance was really poor. Coming out of COVID, no one was prepared to ramp up quite as quickly. This was a once-in-a-lifetime ramp-up of the entire sector, and performance was poor. We fully accept that. But we're talking about going from 11% cancellations to, in Virgin's context, 1.4%. Those rates are low. We constantly want them to be lower. We are financially motivated for them to be lower because that's how you run an efficient operation. That's when your customers are feeling the most consistency, the most support for you. But when things go wrong, do we accept that it's a really emotive issue for customers? 100%. The investment that's required there is twofold. We are always looking to hone the operation to be better, to be more reliable. And second, it's about communication. So the answer to that from our perspective has been a lot of investment in digital. So we have a tool that launched recently called Rapid Rebook, and it actually allows, in that situation, the customer to get a notification. They are informed of their options when it comes to, if relevant, an accommodation option, a meal voucher, booking transportation, and the offers about how they're going to be rebooked. So that has vastly improved that communication. Other similar digital ones, baggage tracking. There's huge anxiety, and my bags actually made the flight. That was introduced, by Virgin Australia. And another one, which again, it's more on routes where there are multiple flights a day, is the ability to fly ahead or fly later. So you're able to do all of that in the app. Do passengers fall through the cracks sometimes?
Is status based on that fly now and fly? Is like, and again, like you guys look after us very well, but does status?
The last one is specifically a tool that is for your gold, platinum and above passengers because it's about flexibility, not disrupts.
So, yeah.
I can add to that. We've just recently introduced Fly Earlier. That's available to anyone, regardless of how often you fly with us. It could be your first flight. And our operations team will activate in the app if we suspect that we might have a weather issue at a particular port. We will have that then available on the app. Any app user can use that to shift to an earlier flight.
Well, that's fantastic to hear, Ms Dunn, and I applaud you for that there. But I'm sure this is going to go some way towards making a bit of a difference. But getting back to it, the way that airlines traditionally have done things, it has caused consumers to use really strong language when referring and dealing with the airline industry, and I hope that they would never do that with your staff because your staff are fantastic. I do just want to get back to Mr Cleary about the comments of Mr Bennett, and on your website, communications. As Virgin Australia team members, everything we say and share reflects on us individually and on Virgin Australia, whether we're in a meeting, having a coffee, walking together or communicating online. What we say and how we say it matters. Truthful and accurate public statements. I think from an executive of Virgin, those statements really rein home to what everyone else is thinking. What's your response?
Sorry, Senator, I'm not sure of the exact question. I understood everything you say, and that is our policy, definitely.
But you still disassociate yourself from Mr Bennett's comments on LinkedIn, considering what your statement says on the website?
It is a social media platform. There were personal comments.
Professional social media platform.
Yeah, whether they align with the policy or not, what I would say is they were personal, they were made by Christian. Do they reflect our company position? They do not.
Mr Bennett also argued that consumers shouldn't be left scrambling to make alternate arrangements, and I'm pleased to hear that that you're starting to do your fly earlier, fly later stuff. I might just ask you about your COVID travel credits that are due to expire on the 30th of June. How many travel credits are still owing to customers, and why don't you just refund the money back to customers?
So how many, the dollar value?
Yes.
93 million was in February reported in our half-year results, 93 million outstanding.
Okay.
And that's proportionately, that's over 90% have been used. These are now between 4 and 6 years old from when they were issued, and the expiry relating to those has been extended 3 times. The current expiry date of June 30 has been flagged many times.
Why don't you just refund the money that's left to consumers?
I think it's important to talk about how we've handled this, and I will ask my colleague Alistair to help on this, bearing in mind the history of the last 4 to 6 years is not something that I'm best placed to talk to.
But I might just put it on the pretext as well, is the COVID era was a dark era for the airlines and for consumer confidence in the aviation sector in the post-COVID recovery. And hearing that already that you've got $90 million that is Virgin customer money that is due to expire on the 30th of June, and I appreciate it's been expired, but it's still customers' money. It's done.
So how we've handled these credits from the outset has been very accessible for customers. We had no minimum booking thresholds at all. You could even use the credit for an ancillary purchase, such as a baggage. You could use them on our metal.
Sorry, I don't want to be rude. We are short for time. Sure. I think the Senator's question was very specific, and I appreciate you want to talk, but sure. I would ask that the question be answered when Senator Deleega did refer, I think it was going to anyone along there. Why don't you just pay it out? I'm not being rude, but I know my colleagues at this side of the table want to ask questions too.
Yes, thank you.
So you diverted to Mr.
Yeah, I did to Mr. Hartley. Yeah.
One moment, Chair.
Sure.
Sorry?
So
I have a couple of questions for you. Yeah. How long have we got? Sorry.
You've got about 5 minutes.
I've got about 5 minutes, yep.
Okay.
Yep.
So I would only reiterate what Mr Cleary has said there, that as we have looked at these, we've been fair and flexible. I understand the question on why can't we, but if we reflect on the COVID issue...
Not why can't, why don't you?
Why don't we? If I reflect on the COVID issue and I look outside of our industry, whether it's hotels, hospitality, whether it's travel agents, whether it's ticketing agencies, all of these other companies have also already expired their COVID credits. So we have taken a decision. We've extended 3 times in this process. We've contacted our customers directly 10 times in this piece, and we've taken a decision that they are going to expire.
So on 30 June, $90 million comes through back to the Virgin bottom line?
They will expire, and that would fall through to our NPAT, yes.
Back to the bottom line. Customers will lose $90 million of money.
Yeah, again, Senator, I would reiterate that we have seen this practice play out outside of the airline industry, and this is a decision that we've taken.
But we're trying to improve the aviation sector, and we're trying to improve the consumer experience. And your submission argued against fair and reasonable standards and stronger enforceable mechanisms. You've got your executive, Mr Bennett, saying other things. What I'm hearing is that you're not going to give that money back to consumers, and it's going to go back to the Virgin bottom line. I might just ask Qantas a quick question. Thanks for coming along today. Jetstar has had historically relied on travel credits rather than refunds in a range of circumstances. How does the airline satisfy itself that those practices are consistent with the Australian consumer law obligations where services are not unilaterally provided as booked?
Thanks for your question, Senator, and we appreciate being here to express our views on the draft bill, and appreciate that it's not finalised and we can provide input. On Jetstar's credit, we take very seriously, obviously, compliance with the law. On our COVID credits, we appreciate what a difficult time COVID was for all our customers, and that airlines were all not performing at their best. in the recovery, but I will say Jetstar's credits, we've put no expiry on. Customers can use them in perpetuity. There's no expiry date on our COVID credits. So we take that seriously, particularly because Jetstar customers are often less frequent flyers. So you might get them flying once a year, if that, and it's hard-earned money saved up to fly with a low fare. We take that seriously, so we appreciate it's going to take some time for them to be used. We still see them being used, but we've deliberately put no expiry on them. And I know, Marcus, I can answer for Qantas as well on this, that the Qantas credits are all refundable forever. So we've taken that very seriously because we appreciate it's our customers' money.
Thank you. And I might just, on my final question then, ask Mr Svensson, is that in your submission, or in Qantas's submission, you state that passengers deserve clear enforceable rights and appropriate dispute resolution when airlines fall short. Do you support the principle of enforceable minimum standards in aviation?
Minimum standard, yes. I think very important in this draft is we can't be too prescriptive because it's impossible to account for every incident or occasion.
Thank you. And just note we started on a very nice note, but I'm out quite cranky now, Chair, after some of the responses there today. I might hand back.
You're always cranky.
Sorry to start with that. So before Mr Samuel's medicine absolutely completely runs out, questions? Senator Cadell?
I'll start for a little bit. I think there's a passionate argument about the why from the government and what we're saying now, but I'm concerned about the how the execution is going forward. I think that is too, and I don't think anything is changed from that after what I've heard. The word proportionate is coming through in a lot of substantives today and how it works. For instance, my reading of this now is Air Services was to not be able to staff a control tower, it would be airlines on the hook for the complaint. Am I reading that correct?
Yeah, you are indeed.
Yeah, sorry.
Mr Samuel?
Professor Samuel.
Yep. Professor.
Yeah, look, you are, and I was going to sort of follow up on a couple of things that had been said before in response to the questions put to Virgin, and then also the comment just made before about minimal standards. I'm sure the senators are aware that we already have in legislation minimal standards that are in place. It's Section 61 of the Australian Consumer Law, which says that any service provider, airlines, airports, whoever it might be, is obliged to provide a service that is reasonably fit for the purpose that the intended party to receive service would expect. Now, that means for airlines and for airports that they expect that that's subject to other intervening events, and I'll come back to that in a moment, that they expect the service to be courteous, to be timely, and to be safe, and the various issues that Stephen Beckett has outlined. So the minimal standard is there. But what the Charter chooses to do is to try and provide a granular description of what those standards might be. And I think that what our concern is that granular description is just simply getting more complicated and is going to cause some difficulties in the future. Canada is a very good example of that, where the complaints backlog there, I think, as I recall correctly, is about 80,000 complaints, and the cost of dealing with each complaint is about $1,400 to $1,500. Well, you can imagine the cost imposition that will occur there. One of the other factors that occurred to me when I was listening to the responses by Virgin, and I heard Senator Colbeck's response to the note that he got this morning from Qantas, is one of communication. Now, the best communication template that I've seen is when we had that horrendous example at Sydney Airport just a few weeks ago, a couple of months ago, when Air Services ran short of staff. It couldn't get people there to man the traffic control. The result of that wasn't, Stephen Beck will be able to correct me on the numbers, but there were countless flights cancelled through the day. I think upwards of tens of thousands of customers were impacted, not only at Sydney Airport, but at airports around the country. Now, I actually happen to be one of those affected. But the beauty of it was that the captain actually came out to the lounge, the terminal waiting area, and he said, look, we have to apologise for for reasons that are beyond our control. Air services don't have enough people to man the air control, and as a result, we are delayed. I'm going to ask you to board the aircraft 3 or 4 hours potentially before it's about to take off, because that's the quickest and easiest way that if we do get a slot, whenever it might be, we can immediately back off from the gate and take off. So I thought that was a remarkable process of communication. And it does seem to me that a lot of the angst that was described by the Senator before in his questions derives from the fact that there is probably not enough full communication to passengers as to why the problems are there. Now, I'm going to take the opportunity as well to address a question that Senator Mulholland put to the airports before. And Senator, if I verbal you incorrectly, please correct me. But you said, isn't this a joint problem? Isn't this a problem of both the airports and the airlines? And
shared responsibility was the word I said.
Shared responsibility, thank you. And yes, I agree it is. But I was a bit taken aback at the AAA's response when they said, no, it's not our problem, it's the airline's problem. And we've got a contractual arrangement with the airlines which says that if something goes wrong and it's the airport's fault, well, then they can make a claim on us, the airport, under those contractual obligations. Can I remind you, and you'll have to forgive me coming from my days at the ACCC, I have a passionate aversion to monopolies. And each airport in this country is a monopolist. And when they talk about their contractual obligations to airlines, they are the obligations that they, the monopolists, dictate to the airlines. They're not the ones that are mutually agreed. They are dictated, and they are limited by the monopolist's dictation. If an airline chooses to turn around and say, you've caused a problem and we're making a claim upon you for that problem, the airport will simply give the single finger salute and say, you forget, we're a monopolist, you've got no choice. So just behave yourself and get on with it. Cross the bridge and get over it. And so it's a really difficult position for airlines to be in. So we cannot understand why, 2 things. The first is having a prescriptive charter that goes well beyond what is already in the legislation at the moment, which is Section 61 of the Australian Consumer Law. And you'll appreciate I'm very familiar with that from my past role with the ACCC. But secondly, to then have an issue where everyone says, it's not us, it's the airline. So Air Services says that, we shouldn't be liable. Travel agents say we shouldn't be liable. Airports say we shouldn't be liable. Airlines, oh yeah, you're the only ones going to be responsible. And the urgent or the urging, I think, that senators could properly put upon the airlines and airports for that matter, is to actually say, communicate well with your travellers as to what the problem is, what's causing a delay or a cancellation. And that might alleviate some of the angst that's been described before in the questions asked by the senator.
Okay, very substantive answer, so thank you for that. Professor Samuel, very brave to go to market power, given VA and Qantas are 99% of the domestic market, but I'll not go beyond that. So if we're seeing
yeah, but Senator, if I could just, sorry to interrupt you.
Yep.
Duopolies do compete vigorously with each other on price and on service, right? Monopolies
and
don't compete with anyone. Monopolies don't compete with anyone.
No, okay. If I go to the next part then, is it fair if we're looking at this legislation, if it was to be better, and I think fit for purpose, I think we're going to a lot of effort and a lot of costs to marginally increase the protections. I think that's where we go now. I don't think it's at a level I would love it. Should there be protections for airlines where they are caused by government or airports for you to claim back those costs in full from them?
Well, of course there should, but what we would say is that, first of all, the protection is there in Section 61 of the Australian Consumer Law. That is, if you're providing a service, it's got to be reasonably fit for the purpose expected by the party to whom the service is provided, right? That's there. And the ACCC can enforce that very easily. We've got the ombuds, which will deal with complaints. Good luck to them, because they're going to get tens of thousands of complaints. I was bemused to read just the other day that Cathay had a problem because of turbulence and it couldn't serve hot meals. And it got a plethora of complaints about hot meals not being served. Well, forgive me, that's the sort of problem you can get into. I'd rather not have hot coffee being spilt by my waist because of turbulence. Thank you very much. But they're the sort of issues that we've got to deal with. But rather than say, airline, you bear the first brunt, and then you go ahead and try and claim or sue air services, or sue the travel agent, or sue the airport, monopoly airport, who will give you the single finger salute, then all these parties have got to be roped in. They've got to be part of it. Okay. But importantly, Senator, and this is the last thing I'll say is, if you've got an ACCC administering this, why in all of heaven would you set up yet another regulator at vast cost? I think the figure that's been mentioned is around $30 million. That'll get passed through to the airlines. The airlines will have to pass that through to the customer. It just doesn't make sense.
I get you a lot of work, a lot of cost, and all that. But I get you on the prescriptive stuff. A very close friend of mine, and I think there needs to be more than what we've got in consumer protection. I'll say that. I think the argument I won't, but the how gets me. Pays $784 for a scoot flight to Greece, right? Braver than I to fly that, but anyway. His compensation on his flight back for being delayed 6 hours was €800. He got $1,380 back in compensation for a $784 flight. I see why the prescriptive model may not be fit for purpose. I think that's a bit adverse. But anyway, Senator Colbeck has the rest of the coalition question.
And Senator, I should just mention one other thing, and that is that when we had a meeting with the department on this, there was a whole group involved, including obviously Rex in its sort of, at that time, slightly re-energised form. But one of the requirements, for example, is that if a flight's delayed by an hour, then food vouchers need to be given to the affected passengers. But Rex then turned around and said, quite properly, they said, well, food vouchers are not terribly helpful if it's after about 3 o'clock in the afternoon, because the cafe closes as this is in regional airports, as the attendant at the cafe goes off to collect her children at school. So what's the point of a food voucher? So it's these prescriptions that just don't meet the required the benchmark of common sense. And that's why I do love the 2 lines that are in section 61 of the Australian Consumer Law.
Mr Becker has a question before it goes over.
Just in relation to what you're saying, it incentivises complaints as well. So if you've seen in Europe the growth of a complaint agent, a no win, no pay.
One mentioned,
where you'll get off at Heathrow and there'll be a billboard, was your plane delayed, we might be able to get you some money. About anywhere up to 40 to 60% of the compensation that is paid is actually being withheld by these corporates that are now running complaints. And so what it does is it actually drives more people to complain, because it's just simple to do and you can hand it off to someone even if you really aren't that particularly upset. Also, the growth of AI and AI complaints. So we need to deal with this proportionately. If we open the floodgates and have a very heavy administrative burden for dealing with all of these complaints, we're seeing it in just about every industry where the number of complaints are coming in because someone can get behind a computer and put an AI complaint in. So we want to work hard, and back to our point, everyone should play their part and everyone should play their role. Our concern is the burden is falling almost exclusively on airlines, and to our members like Jetstar, who are a low-cost model, they have people fly with them who wouldn't fly otherwise. It's not about flying with Jetstar.
That's our premium airline.
Yeah, so which is wonderful. It means hard-working Australians who ordinarily wouldn't be able to fly can do it. It's not about choosing a cheaper option and having more money to then spend on cocktail. This is whether you get to fly or you don't get to fly. So to keep putting that lead in the saddle for airlines like that, they're really at risk.
Yeah, I think it's really important to consider that point, because we've really got a prescriptive one-size-fits-all draft in the Charter, which, to be honest, would undermine Jetstar's existence. So, we've got to make sure that this is workable. There are many things that we are seeing in the Charter that are just not pragmatic, thinking about things inside, outside control, thinking about the whole ecosystem, thinking about, at the moment it's drafted that the marketing carrier would bear the responsibility. That is not a thing that happens in aviation anywhere in the world. The operating carrier should wear the responsibility. They are the ones flying the planes.
So if I come to Canberra via link flight bought by VA 004 or something like that, technically you would be on the hook for the link non-performance.
Yes.
Okay, good to know. Thanks.
Just not pragmatic and workable. We want to work together to make this workable, pragmatic, but not undermine. I think the thing is, airlines are extremely motivated to get this right. It's lower cost for us to get it right. Our people are happier working when we get it right, and we know customers like us more when we get it right. So let's work together on that.
I heard the chuckle. Good luck.
No, I'm fine. I'm just corresponding with your wonderful people, and I've got to say how much I do appreciate your team, particularly the cabin crews that we fly with, backwards and forwards across to Tassie. They are really, really good people, and they do a great job. Really appreciate the engagement, and I'll work out the rest of my problems as the day goes on.
I don't think you got that one.
No, I don't. I have to make a decision very quickly about who's the winner in terms of who I'm flying with today.
You have to sit in Canberra and watch Geelong flog Carlton tonight, mate. Sorry, thinking aloud.
When you know who I support, anything's on the upside there, Stella. So, I mean, effectively what you're saying to me or to us is that nothing should change here. You're all doing a terrific job and we don't need to make any changes to the system.
No, I don't think that's right, Senator. Sorry, I think that Stephen Beckett in his opening statement said that the airlines, represented by ANZ, and I think BARA has said the same, welcome the concept of some more clarification as to what Section 61 of the ACL of the Australian Consumer Law provides. But it can't be a one-size-fits-all for the reasons I, for example, described in respect of the example provided by Rex at the departmental meeting that we had. But by the same token, you can be so prescriptive that what you end up doing is putting a straitjacket on something which is probably better represented by the two lines in Section 61 of the Australian Consumer Law. But look, it's a bit like what the ACCC does, and they certainly did in my time as chair. We used to issue guidelines so that when someone was concerned about there being unconscionable conduct, and there are about 10 lines that a court could take into consideration, we'd issue a 3 or 4 page guideline as to what unconscionable conduct was as we interpreted it, right? And I can well see guidelines being issued, for example, by the ACCC as to what is reasonably fit for purpose. They already have a document that deals with that, but it might well be that they issue some guidelines with the assistance of the minister in this case, outlining what they consider reasonably fit for purpose means in respect of aviation services. But that should cover everyone, should cover air services, should cover travel agents, airlines, airports, everyone that's involved. And it should express it in terms that leaves it for or enables the customer to know pretty clearly what they should expect and what they should reasonably expect. And then, of course, as I said before, communication is a very important element of it. To be able to say, as was the, I have to say, sort of semi-pleasant experience that when we got delayed by air services, having inadequate people at the control tower, at least the Qantas captain came out and he said, "I'm sorry, ladies and gentlemen, this is the problem and it's beyond our control, but I'm going to try and do everything I can to make it easier for you and easier for all of us to take off as soon as we get the opportunity."
So any structure that we're talking about, your view would be that it would be best placed within that ACCC structure rather than in the department, which is being proposed in the legislation?
Yeah, I cannot for the life of me, Senator, see why you would want to duplicate what is, you'll forgive my perhaps hubris in this, but what is an outstanding regulator in the ACCC. And if we say to the ACCC, please provide, with the guidance of the department, a set of guidelines as to what is meant by Section 61 in respect of aviation services, provide us a guide, can be a charter, can be a guidelines, could be whatever it is, so that airlines and others can then turn around and say, first to themselves, as airports can, this is what is reasonably expected of you in relation to your customers. and the customers can say, now I know what we should reasonably expect to be the case. But to be saying, for example, 1 hour leads to certain consequences, 59 minutes doesn't, doesn't make sense. It's not common sense, frankly.
When you're talking about all of the different layers of or participants in the process, so how about something like running out of slots at Sydney Airport, for example? I mean, that's not within the airline's control. Weather's not within the airline's control. No. It's a systemic thing. I mean, how would you deal with something like that?
Senator, our concern is for consumers, it will be confusing and suboptimal. You can have someone at a gate that is being delayed by, say, an engineering issue that is within control of an airline, and this customer ombud scheme would kick in and support them. Someone at the next gate is impacted by an air traffic control delay out of another airport because that's not within the ombud scheme. They won't be covered by this. Same with the problem is there are so many participants. We all need to be in and we all need to work together. Otherwise, you're going to have this patchwork quilt, more confusion for consumers, and a whole lot of people when they go to lodge a complaint and find out that, in fact, their delay was because of air services, so it doesn't apply.
But that's dependent on effective communication, which Professor Samuel said before, and for Qantas's benefit, their disadvantage today is because of good communication, because your system works.
Can I just say, unfortunately, Link also has good communication. I just got my text, my flight's delayed as well.
So behind the scenes while we're over here.
We'll have to find out what it is. It might be a common issue.
And I'm not flying today.
I mentioned my flight number like 5 seconds ago.
Mr. Spencer and I had a conversation 5 minutes before I got my text to say things should be all okay. So, I do feel sorry. I do feel sorry for him.
It's interesting, Senator. I addressed this to Senator Colbeck, but it's interesting. And that's why I was actually delighted to Senator Mulholland's question to the AAA. This is, and I think I've got the word right, Senator, this is a joint responsibility. And whether it's the responsibility of airlines, of slot allocation or slot availability, of weather, of air services, of travel agents, mistakes, all those things, they're all relevant. And to simply say, because we've got two big gorillas there in the Qantas and Virgin, well, let them take the responsibility and then they can sort it out with these other parties, just doesn't seem to me to be common sense, particularly when you're dealing with monopoly airports, because having dealt with monopolies all my, at least for nearly 20 years involved in competition policy, I can tell you monopolies are the toughest lot to deal with.
So in terms of the way that this legislation is structured right now, what does it change in terms of what your practice will be from what you're currently doing? I mean, what's it actually going to make you do? I mean, you say it take responsibility as airlines basically for everything, and I've got to say I'm not completely sure about that. Although because I'm someone who flies a lot, I do get the nuances of particularly weather and things of that nature, and so pretty pragmatic about those sorts of things. But what do you see this will change from a consumer perspective? What do you see this legislation actually changes?
Well, I think there will be 3 or 4 things. The first is the consumer won't have any idea about what it is they're entitled to because it's so granular and so specific, and so they won't be better informed. The second thing is that rather than the airlines being obligated to do everything they reasonably can do to meet the reasonable expectations of customers as required by Section 61 of the Australian Consumer Law, now what will happen is you'll have a ticker box. 59 minutes, okay. 1 hour and 1 minute, not okay, right? And then various sort of consequences that flow from that. And this is one of those circumstances where I would rather have airlines and airports and air services and travel agents and everyone else involved in a position where they have to do their very best to meet the obligations under Section 61 of the Australian Consumer Law, that is, to meet the reasonable expectations of the customers that they're there to serve. That involves, in my view, two or three things. The first is look at your systems and what you're doing at the present time and see, is there any chance of improving? I think that the responses given by Qantas and Virgin and Mr Beckett before will indicate that there's been a lot of effort put into that, particularly post-COVID, number one. Number two, communication, so that the sort of example set by Qantas, and I was flying Qantas that day, but I'm sure the same thing was done by Virgin, but that the communication, when air control, you simply didn't have enough people in the control tower to be able to safely allow flights to take off and to land, that at least the passengers knew what was going on, and they said, well, we're tearing our hairs out, but frankly, we know you, Qantas or Virgin, as the case may be, have got no choice because this is an air control problem. But for some reason, government has currently chosen to exclude air services from any responsibility. Well, Senator Mulholland, when you talk about joint responsibility, it seems to me that everyone that's responsible for the inconveniences sustained by customers, by travelling customers, ought to bear some responsibility for it. It shouldn't be up to the airlines to bear the responsibility and then try and make some claim against air services or the airports, the monopoly airports, or travel agents or whatever might be the case. It's just, it lacks any common sense. And then, as I said before, and I'm repeating myself and I won't do it again, when you've got a very capable regulator there in the ACCC, why duplicate it with another one at a cost of $30 million to our travelling customers? It doesn't make any sense at all. And the Ombuds is there to deal with the complaints. The ACCC shouldn't be dealing with those. That's not their role. But they are there to enforce systemic failures by airlines and airports and others in carrying out their responsibilities under Section 61 of the Australian Consumer Law.
Mr Beckett, you wanted to add to
that? This is part of the wave of cost that's coming towards airlines at the moment. And you've seen the bite of high fuel prices and what they're doing to your constituents. You will see in your regional areas that you represent in your home states, services being wound back, suspended and the like from all players, all carriers, particularly some of the little ones. And we have this wave of cost coming. We've seen airport fees double in the last 12 months. We've seen new taxes and charges coming in. There are more coming. This wave of cost that is coming towards airlines is going to have that same bite that fuel prices will if left unabated. And as I said earlier, we don't want air travel to be something that the well-heeled can only afford. One of the greatest things about our aviation system now with a value carrier and a low-cost, there's an airline for everybody to serve every part of the market. And I just probably invite one of the airlines to just talk about that wave of cost and how real it is for the future growth.
Make it easy for you, Mr Beckett. We're going to run out of time, and that's not being rude. And we understand, and no more than this committee does understand, because we deal with transport. That's in our title. We get that.
So we're talking about it right now.
Yep, we are. So thanks for that. So Senator Mulholland, did you want to wrap up the last one, and then we'll go to a break?
I did, thank you, Chair, and I do agree with Mr Beckett and Mr Samuels. From a consumer perspective, it's an end-to-end journey. People don't distinguish between an airport delay and an airline delay. A delay is delay. So I think you won't get any argument from me about the need to include airports, particularly the big major airports, in this framework. What I did want to pick up on just quickly is around I know that we've focused a little bit on travel credits from Virgin. I did also want to touch on some of the feedback that we get around the product Qantas that you have, particularly offered through Jetstar, and I want to acknowledge how hard the staff work and what a great product Jetstar is for providing, particularly my part of the world, affordable airfares for, like Mr Beckett said, people who may not ordinarily be able to afford airfares. So I want to acknowledge that straight up. One of the things that we do get asked about is around the Jetstar offering, and it's particularly not offering refunds and going more towards credits, and also its product around the no refund fare and how your approach to those fares sits within the Australian consumer law, because we will have the ACCC on a little bit later this afternoon. We will be asking them that question because they do have expressed some views to us in that space. So I welcome your evidence in that regard.
Yeah, I'll take that. Thanks, Senator. I think firstly, it's good you acknowledged Jetstar's role in this country, because for 22 years, it was our birthday earlier this week, we have democratised travel.
Happy birthday.
And we have, even this week we had fares in the market for $30, which is what we had 20 years ago. And the reason we're very passionate about things like this is that cost that's coming from all angles really threatens Jetstar's ability to do that and ability to fly on many routes and to fly at the affordable fares, which is what we are all about. We take our compliance with the Australian consumer law very seriously. Jetstar's policies around refund and credit have been unchanged for its 22 years. Those policies differ whether a delay or cancellation is inside our control or outside our control, which is why those definitions are very important and shouldn't be undermined with whatever's being considered here. So we will provide refunds where it's an option to do so, where it's within our control and the delays of a certain amount of time. So we're very confident what we do is in line with the consumer legislation. We take that very seriously, but it is a very important point to know that low fares carriers will generally have different policies around these things. If you go around the world, you'll see that's the same in most markets, because doing things like that is what enables the low fares to be delivered and have them, still make a margin so we can invest in fleet, etc., which ultimately leads to job growth and flying affordability growth. So it's a vicious circle, I think, when you start to add more costs unnecessarily into that system, and we'll always be really passionate about defending Jetstar's role in the market.
Thank you for that. Just particularly on that issue around the non-refundable fares, particularly where you market those fares as being non-refundable, where flights might be cancelled, and as a result of issues outside of the airline's control. One of the things that the ACCC has spoken to us about in their submissions is that people are entitled to refunds under the Australian consumer law. However, that may not necessarily be marketed to consumers at the point of sale on product. However, those rights under the ACL still apply to consumers. So it is a thing that gets raised with us. I appreciate trying to drive down the costs. I really do appreciate your position in the market and the services you provide, but there is some concern that gets raised with us as politicians around those non-refundable fares, the way they are marketed to often vulnerable consumers who are going for that option, who may also not necessarily be getting advised about what their legal rights are under the Australian consumer law. To have a refund.
We take our compliance with the consumer law very seriously. We very clearly outline our terms and conditions, and we work very regularly with the ACCC on making sure that they are fair and reasonable. So always happy to take particular cases and have a look at them, but I'm really confident that we are in compliance with all the things we need to be in compliance with and are very passionate about doing so.
Wonderful.
Thank you very much.
Chair, just before we go to our lunch break, if I may, my office has just been asked where I was quoting about the Virgin team members, and just for the record, that was from the Virgin website on the Code of Conduct, and I have got a copy of that, which I'm happy, if the committee is happy, to table that. Thank you. And also, just finally, a comment, Mr. Svensson, and to the Virgin crew, Rex, and I'm sure Senator Colbeck will agree. Rex has recently announced that our local airport, that they are ceasing operations into our local airport in Devonport. There is a great opportunity to provide a service or increase services to the people of Northwest Tasmania. So take that one as a comment, and I'm sure in other inquiries we might ask you further again.
Mr. Svensson knows my views on that. We had a good chat about that in Albury, and I appreciate the conversation. I just want to ask one more question with respect to the practicalities of what we've been talking about. To the two airlines in particular, what proportion of times where a flight significantly delayed or cancelled, do you offer A, a full refund, or B, a flight credit? And is that contingent on an offer rejecting a rebooking or a flight credit?
Senator, we might have to take that on notice. There's a lot in that. One thing we can tell you, I think, as a headline stat, is that 60% of cancellations are 60 to 70%, actually this year 70%, are entirely outside of our control. So in that circumstance, you would not be looking to a refund. But can we take the full question on notice?
Thank you. Same with...
We missed the last part of your question. Sorry, Senator.
If...
yeah, you've gone soft.
I am going soft, aren't I? No, there is a sting in the tail. Are refunds offered up front or only if a customer has rejected a booking or rejected a flight credit?
Sorry, I think we maybe you want to start. I'm sorry, I don't fully understand the question, Senator.
Look, we'll get it to you. You can answer on notice. And so the pressure is off you, Mr. Svensson. The pressure is now on Virgin to get me home tonight. Virgin wins or loses, depending on which way you look at the case.
Understood, sir.
Great. On that,
I don't want a text from Virgin to say my flight's been cancelled this evening.
Come down with me, mate. Can I thank our witnesses? Thank you very much for coming here today. Professor Samuels, I love your work, mate, because you and I have worked very closely. I don't know if you remember 20 years ago when lawyers were chasing me around the country around unconscionable conduct, and you were a shining light to the trucking industry and the owner-drivers. Thank you very much.
Thank you, Chair.
Professor. Thank you. All right, well, let's suspend. Yeah, 1:15. We will come back at 1:15 where we will hear from the Australian International Pilots Association. welcome Mr. Kerr and Ms. Mehta from the Australian and International Pilots Association. I understand that information on parliamentary privilege and the protection of witnesses giving evidence to Senate committees has been provided to you both. Now, for the Hansard record, would you please state your full names and the capacity in which you appear today?
Thank you, Senator. My name is Disha Mehta. I'm a senior in-house lawyer at... Sorry, can you hear me properly?
You're very softly spoken. You might get a bit more volume. Thanks. Thanks, guys.
No, I can raise my voice.
Yeah, right.
Disha Mehta. I'm a senior in-house lawyer at the Australian and International Pilots Association.
Thank you.
And William Kerr, Head of Government and Regulatory Affairs with the Australian and International Pilots Association.
Tremendous. Thank you very much. Would you like to make a brief opening statement before we go to questions?
Yes, we would, Senator. So the Australian and International Pilots Association is the professional association that represents the industrial, professional and safety interests of over 2,500 Qantas Group pilots in airline operations within Australia and around the world. APA supports the government's commitment to strengthening consumer protections. Flight crew alongside cabin crew are often the first people that are queried by customers about what the consumer is entitled to during a disruption. Aviation is a service industry, and passengers deserve to know what rights they have and what assistance they are entitled to when flights are disrupted. In our submission on the bill, we affirm that whilst consumers must be supported during a disruption, safety must always be the primary consideration. Flight crew have a statutory responsibility for the safety of passengers, crew and cargo, and must be able to fulfil their responsibilities without additional implicit commercial pressures arising. As one example, and certainly not limited to, this will be acutely felt under the proposed ultra long-range operations referred to by Qantas as Project Sunrise. These flights will push the envelope of flying as well as our understanding of fatigue and the ways in which it should be managed. The expected operations will allow for planned duty periods of up to 23 hours, extendable up to 25 hours. Flight crew are bound not to operate when their performance is or could be impacted by fatigue. With little margin between the planned duty period and maximum extension, any delay during these planned flights may result in flight crew feeling implicit commercial pressure to operate, despite the potential for increased fatigue and associated performance decrement. Flight crew must be able to make safety decisions without additional commercial pressure and without fear of retribution. Given these concerns, it's recommended that the bill and/or its explanatory memorandum are amended as per our submission. We thank the committee for the opportunity to appear here today and are happy to answer any questions you may have.
Thanks, Mr. Kerr. Are you a pilot?
I am not a pilot.
Okay, no worries. Would you do me a favour and pass on to your members our sincere appreciation, because there is nothing more rewarding or nothing more comforting when you hear a captain speaking and all is well and all's good. And it was raised earlier on today, communication. And of course, what we're talking about here, there's nothing worse than delays and all this sort of stuff. I'd had my little rant and spiel about sitting on an aeroplane and not knowing what's going on. All right for me while I'm sitting up the pointy end in the comfortable part, but the poor devil's jammed down the back or in the terminal fighting with 3 or 4 kids and everything's laid or put off. So please pass on to them. When the captain comes over and tells everyone what's going on, there's nothing better.
Absolutely, Senator. And interestingly, we spoke with our colleagues in Canada about their experience with the regime over there. And they said one of the major things that actually really helps them is that all of the requirements about communication and everything are now in their flight administration manual. So it's very explicit to them when they communicate, how they communicate, and the information that they must pass on to passengers, which I think is only a good thing.
Oh, nothing worse than sitting there like a wood duck not knowing what's going on, you know, so that's really good. On that, let's all go home. No? You want us to ask some more questions?
Well done.
Senator Cadell.
Thank you, Chair. I would say as an ex-pilot, the sayings you don't hear, like any landing you can walk away from is a good one, would be more concerned. But you raised Canada then, and you raised those safety concerns. Are Canadian members of similar organisations, and I imagine it's not even duress, it's the implied concern, linking all these things together. You mentioned Project Sunrise. If I'm close on my operating window and do I sign off on something that's a 50-50 call, making it 60-40 to get in the air to make sure I'm not extending? If I extend beyond my 23 or 25 due to headwinds or something on the way, am then liable for breaching the rules of operation. So is that what our concerns are? And what was the Canadian experience?
That is absolutely our concern, Senator, that there is implicit or explicit pressure that is placed on flight crew to do something that they may not otherwise do. But I guess, overwhelmingly our members are incredibly conscious of safety, as you would understand. And, a lot of that pressure already exists around on-time performance and everything else. So I guess we just want to make sure that the bill doesn't prevent or include in there any safety-related elements to make sure that, the absolute obligation on flight crew and their licensing requirements is not countered by the bill. And the experience, I guess, from our colleagues in Canada when we talked to them was overwhelmingly that no, it has worked. They have carve-outs for safety in terms of, if there's unplanned maintenance, a defect that they find or a bird strike that they find on the walk around, that's kind of carved out from the legislation there, as we understand. And looking at the draft charter, we've had great engagement from the department. There are a lot of those carve outs in there, which is great to see, so that flight crew can still exercise their duty in terms of safety.
Now, you put in your submission in the EM, you want safety specifically listed in there, I think, and you want that to define what safety-related things are as well?
More just to, I don't think at the moment the bill refers to the civil aviation legislation, and that perhaps it would be beneficial for it to do that. I do understand, talking to the department, they have sort of advice from CASA on that, and I understand they're appearing this afternoon, so an opportunity to discuss that with them.
So given this section of it is primarily a consumer protection bill, but equally we never want to question safety, finding that balance where it is no fault of the airline nor the pilot nor anything, if we get a lightning strike, if we get a bird kill, if anything like this, how would you say we still protect the consumer being able to claim, given that it's equally not their fault that they can't get on the plane?
Absolutely, Senator, and I think the challenge will be decisions taken at a time and a place. I think that will always be contentious, and you may have seen recent articles out of Canada with regard to WestJet, and how they may have been misattributing things. That is obviously the situation that we don't want, and I think it will be very incumbent on the regulator and the ombudsperson to have appropriate access to information, common delay codes, we don't have those yet in Australia, but also expertise that can actually go in and check the validity of what the airlines or others have attributed the delay to.
Right, we've seen on, I think, the descriptions, the rebooting of industry post-COVID, and we've seen a lot of delays, cancellations, they're coming down, but they're still higher than they were pre-2019. Is that already putting pressure on pilots in a lot of time to actually, the on-time delivery, the cancellation, to try and fix those things already?
Absolutely. On-time performance is always, measured and checked. I think our members are very strong, though, on, we want to make sure everything is good before we depart. And, our members absolutely 100% safety is the number one priority. So they'll always take the conservative option.
Okay. And the priority is not only a moral obligation, but it's also they're personally liable under the civil aviation legislation. So that's again an issue with competing interests.
Okay, so good submission. Get those things. We heard a great thing from Professor Samuels before about the actions in communication you were talking about, where he came out, gave informed knowledge to everyone and let them make a decision what was going on there, and that was great. But you just want to see protection for your members, enshrining safety, largely agnostic to the rest of it and how it operates, just protect our members and our passengers. Is that right?
Ultimately, at the end of the day, yes. We want our members to have that protection, that they're not going to be put under additional pressure, and no fear of retribution as a result of that. And equally, yes, consumers should know what they're entitled to. As a flyer myself and as a consumer, the ability to know what I'm entitled to and when I'm entitled to it. Understand, saw some of it earlier, that some of you have had flights cancelled, and what you're entitled to in terms of that. And I think that's incredibly important, because there are times when you do need to get somewhere and the airline cancels a flight. And I think looking at the proposals under the charter, they give people that option then to explore other avenues of, is there an alternative airline that can provide that service that then has to be done. I think those are incredibly important to provide people the certainty of what they can expect, because at the moment it varies wildly.
You mentioned about on-time performance as a key metric or a potential key metric. Is that part of the KPIs of some of your members under any airlines in Australia? Are there bonuses or penalties for?
Not that I'm aware of, Senator.
Okay. Well, thank you, Chair. That's all.
Yeah, thanks, Senator Cadell. I know Senator Mulholland has some questions, so we'll shoot out to Brisbane. You there, Senator Mulholland?
I am. Thank you very much for that, Chair. And thank you very much for joining us, to our witnesses. I think is there an old saying that says that you've got old pilots and you've got bold pilots, but there's not that many old, bold pilots getting around. And I know that's a bit of a sort of a crass turn of phrase, but what came through to me pretty clearly in reading your submission is that the number one decision for pilots and for crew is that safety is paramount, and there's a real concern around feeling like you could be potentially pressured in that space if there is a monetisation around delays and cancellations. Is that correct? Am I sort of characterising that correctly?
I think that would be a reasonable characterisation, yes.
Sure. Thank you. Could you talk us through that a little bit further? So the concern is that, so as I read it, your concern is not that passengers shouldn't be entitled to be able to seek recourse of alternative routes, different options or refunds, but how does this framework and the way that this framework would then be operationalised by airports and airlines to make sure that pilots and crews aren't feeling pressured to make operational decisions that could be inconsistent with safety? Talk me through that a little bit more about what concerns you and what you want to see to make sure that doesn't happen.
I think it was heartening to hear the discussions from the airlines and their submissions that safety is paramount. So, I think we're hopeful that this isn't an issue, Senator. However, as my colleague pointed out, the way the civil aviation legislation is written is it's an absolute liability on the individual. So as the pilot in command, the ultimate decision for the operation of the flight and to comply with the legislation and all the rules, it's an absolute liability on them individually to complete that. And thankfully our members are mostly with a very large airline or group of airlines. But obviously, there are many other operators out there, much smaller, which might feel greater pressure to operate when they may be taking an aircraft. And sometimes it might be something, and I don't want to say trivial, but a decision about what a flight crew wants to take. So forgive me for getting technical, but aircraft have what they call minimum equipment lists. So an aircraft might have multiple GPSs, as an example. They have 2 or 3 GPS on board. One of those may not work. An engineer can sign that off under a minimum equipment list, and the aircraft is still serviceable to be used. However, that might place limitations on what approaches the aircraft can do or places it might go. And that might be fine on a beautiful, clear day that you don't need it. You can do a visual approach, but it might be in marginal weather, and then that puts the pressure on the crew as to whether they accept that aircraft or not. So it's those I think it's those marginal situations, Senator, that we would want to avoid, that anyone feels any undue pressure to operate, because seemingly they've got a serviceable aircraft, but it may not be the one you would want for that particular operation.
I always get nervous when I have these inquiries and people start talking about safety issues in planes. It's like going on a cruise but watching Poseidon Adventure before you go.
So it's certainly not. I would please don't say I'm saying it's a safety issue, Senator. It is perfectly legal, and it is absolutely the way that aviation operates and the way it needs to operate.
It's Friday afternoon, light humour from
No.
That's all the time.
Please just, I'm not saying it's a safety issue.
Sorry to interrupt you.
No.
No, I was just going to say, Chair, that I know that, it can also be workplace health and safety issues as well. Like, I was on a plane the other day and they were trying to get the toilet to operate and they couldn't get the toilet to operate, and it was a 2-hour flight, and that's not ideal for the staff and not ideal for anyone else on the plane. But as much as some customers tried to give assurance that they wouldn't need to go to the bathroom on the plane, we know that that's not the case. So sometimes it can be something as small as that. But from a workplace health and safety perspective to staff and customers, they need to have a plane that's fully operational and the toilets flush. So I appreciate that. But I'll just move to my final point. So we've definitely heard loud and clear the feedback around safety being paramount in this. I would just welcome your thoughts around just the general consumer protections in this bill as well, if that's something that you also see as having value. That I suppose the converse of it is that there might be some peace of mind for a pilot or a crew to go, well, we've made this decision, but we know that the customer has a recourse under the law through the refund process or the route process, and we know that might also give people that that peace of mind in making the decision that's the right decision.
Absolutely, Senator. I think as I say, the experience that seems to have been from Canada is that it does help, particularly around those communications. But also, if you know that you're going to potentially be cancelling a flight and it's the last flight of the day, that the passengers are going to be looked after, particularly if it's not a capital city, if it's a remote or regional area, that accommodation is challenging for people. You might be at the end of a holiday, or know that someone's at the end of the holiday and they're coming back, and suddenly it's, it might be the start of school holidays and accommodations at a premium or whatever else. You know that passenger then is going to be looked after and dealt with, which, our members do care. They want to know that passengers are looked after. They will spend time coming out of the cockpit, making sure everyone's got what they need, as will cabin crew. Our members understand that it is the passengers that pay, and it is them that effectively pay their wages, and they want to make sure that they get the best experience and are looked after.
Thank you very much for your evidence. I'll hand back to you, Chair.
Thanks, Senator Mulholland. At least we do know this, Mr. Kerr and Ms. Mutter, that your members, we know that they're going to be around for a long, long time, because there is not one single Australian I've met who goes, I can't wait for automated aeroplanes to come into, This will be great fun.
How much does it now?
Yes. Senator Colbeck, since you've got a little more time on your hands, would you like a question? Or I'm sorry.
Senator.
I'm sorry. He had his flight cancelled while we were in here in the hearing. And Qantas and Virgin were in here. Sorry.
No, I think Senator Cadell's covered things pretty nicely. And
tremendous.
Thank you. So I won't prolong anyone's agony.
Thank you. Mr Kerr, Ms Mutter, thank you very much. Thank you for coming all the way down to Canberra and giving us those insights. And as I said, please pass on to your members our sincere thanks. And what we will now is we will now call Mr Rob Walker from the Regional Aviation Association of Australia. And Deputy Chair.
Thank you. Thank you.
Thank you. See you, brother. See you for the weekend, eh?
Travel safe.
Yeah.
Should have come with you.
Who's on this for you? You're Corrine. Who's on Rob? Yeah. Thank you, Mr Walker. Thank you. Welcome back again in front of this committee. I understand again that information on parliamentary privilege and protection of witnesses given to the Senate committees has been provided to you. For the Hansard record today, will you please state your full name and the capacity in which you appear today?
Thanks, Acting Chair. My name is Rob Walker. I'm the Chief Executive Officer of the Regional Aviation Association of Australia.
All right. Do you have an opening statement? I'll now invite you to make that opening statement.
Thank you, Acting Chair and Senators. I do. And can I say from the outset, thank you very much for your ongoing support of and your interest in regional aviation is greatly appreciated. As many of you know, the Regional Aviation Association of Australia has been advocating on behalf of our 130 member organisations who provide the vital services to keep regional aviation running. From the outset, the RAAA supports the intent of the legislation and the shared view that there needs to be ongoing transparency and fairness for aviation consumers and, from our perspective, the continued safe delivery of the vital services to regional and remote communities across Australia. Today, I'd like to add 4 key points from our perspective about this legislation. First, as it's currently presented, the legislation does not have enough information and lacks clarity to determine the real impacts on regional aviation. It does not include the charter, which still has not been settled, and it lacks detail around key areas like costs and proportionality of those costs. The legislation risks blurring the lines between existing consumer protection, anti-discrimination and disability legislation. Rather than providing clarity, it may introduce more consumer confusion. The RAAA firmly believes that the outcome or the impact of this legislation will be more regulatory compliance, increased costs and, unfortunately, greater burden on regional aviation. Second, safety must never be compromised. In Australian aviation, safety is first and safety is last. No aviation participant should be put in the position where they effectively need to choose between safety or schedule. All aviation participants, be it an airline, a pilot, cabin crew or an airport, have strict regulatory responsibilities described in the Civil Aviation Act. This legislation is silent on those obligations and has the potential for unintended consequences of diminishing the awareness and effectiveness of the safety legislation. The threat of fines or penalties will inevitably lead to pressure to ensure airline on-time performance. Thirdly, the RAAA welcomes the government's decision to exclude regional airports with less than 1 million passenger movements. We would encourage the government to extend this and also include, or rather I should say exclude, regional airlines who do not have the size and the operational resilience of larger aviation operators. And my fourth and final point is around cost. Regional aviation is a tough business, as you've been witnessing firsthand as you've participated in other inquiries and toured around the country. Margins are tight and many regional routes are already running at a loss or close to it. Any legislation that introduces more costs will have an impact on the sustainability and the survival of regional aviation. This legislation and the proposed charter include no qualification what the costs will be or how they will be proportioned. Any costs should be proportionate and not penalise good operators. It appears to be a one-size-fits-all approach. All contributors in the aviation system must included in the scheme. All participants must be included in the scheme, not just airlines and airports, but they should also include the government agencies as an integral part of safe and on-time aviation operations. In summary, the RAAA members appreciate and support the need for consumer rights to be protected and upheld. But we need to ensure any new regulatory framework, Aviation Consumer Protection Charter and the associated ombud schemes are fit for purpose. Responsibilities and costs are apportioned appropriately and the costs do not negatively impact the communities of regional and remote Australia. Thank you, and I'm happy to take your questions.
Thank you, Mr Walker. I'll throw to Senator Mulholland.
Thank you very much, Acting Chair, and thank you, Mr Walker, for joining us this afternoon. And can I extend my thanks to you and your members for the work that you do in regional Queensland. If it wasn't for those airlines servicing those parts of the world, many people wouldn't be able to get to the hospital or get to work. So very much appreciate the work that you do. With that in mind, I was reading, I think it was the Department of Infrastructure and Transport's submission as well, and they talked about the fact that many of our smaller airports do not have the staff or resources to implement measures, and goes on to say that there was a survey data that Some are losing $200,000 a year to keep aircraft moving, runways open, and nearly 60% are operating at a deficit. Look, we know just how precarious the regional airline market is. We've seen some go to the wall. We've seen some hang on by their fingertips. Talk me through some of the considerations and the recent announcement from the government around having a bit of a carve-out for regional airlines in the new consumer framework.
Thanks for the question, Senator. As you've quite rightly pointed out, regional aviation is quite tenuous in an operational sense in terms of the operating margins and also the ongoing sustainability. And I think for regional aviation more recently, on the back end of COVID, we haven't necessarily seen the recovery that larger airline and domestic operations in international have enjoyed since the COVID decline. I think there's a long tail in some of those operational challenges, things like supply chain, the lack of spare parts, the lack of new aircraft alternatives, and dare I say it more recently, the fuel crisis has had a really dramatic impact on our sector particularly. And going forward, we really do believe that in terms of that proportionality argument, there should be some relief, for want of a better word, for regional airlines who don't necessarily have the scale and I suppose the network resilience, let's describe it as, that obviously larger operators do have. Having said that, as you very well know, flying in regional aviation, it's a different experience. It's the aircraft in some instances will go when everybody is ready to go. Our member airlines tend to be the beginning of the journey for some people and also the end of the journey for others. Our members feed into a much larger network or a hub and spoke model, and part of that means that if the incoming passengers are late, they're late, and also if the freight or the medical supplies need to go out and they haven't been delivered or arrived at the airport in time, there's a general consensus that the prioritisation of the flight comes first in terms of not so much the passenger experience but what the flight is actually intending to do. So in terms of your question around regional aviation, we're not saying we're special. We're not saying that we deserve something better or above anybody else. We're just saying that we are different, and that difference is just part and parcel of the operations that our members perform.
And it's important that we recognise that, I think, in the framework and the approach to the framework, that you are different. One of the, I think you talked about the fact that regional airlines don't have I think you said the network resilience that some of the other big airlines have, and I think that's even a larger argument around the approach the government's trying to take in this bill to having a fairly adaptive approach to the framework, which can be responsive, but at the same time, it's not too prescriptive. We've had a few witnesses from the consumer space early this morning advocating for consideration around the European and the Canadian models. And I think, we drew comparisons between the Australian aviation market and those markets, much denser markets, much more network resilience to be able to deal with it. But we're also talking about models that have several hundreds of dollars, the quote, pay for delay, and I would fear that would have a significant impost on regional airlines who are already operating at the margins, and we've seen Rex come back from the brink thanks to a lot of government support, and I would be really concerned that in trying to do something good, we ended up doing something that created an almighty situation for regional airlines.
Yes, no, I agree entirely. I think you quite rightly raised the example of the Canadian experience. And if you look at the Canadian experience in a regional aviation context, and similarly in the regulatory context as well, there's a lot of alignment between Australia and Canada. We have populations concentrated predominantly on the eastern and western seaboards. We have a very complex network with the challenges of vast geographical distances. And I think what is concerning to regional aviation is when we look at that Canadian model, which seems to be effectively the mainstay of what's been proposed here, it's proved not to work and not work for the interests of regional aviation. The big numbers that I'm aware of is the log of complaints is sometimes up to 3 years in delay for those complaints to be assessed. And as you quite rightly point out, there is a financial impost on the operator. It may go through the system and be, I suppose, finalised, or the outcome is that the airline did everything they could possibly do. But just the mere existence of the process and the requirement to be part of that process does create that final impost. And our concern with cost across the board is that question of proportionality. I'm not saying that every operator is perfect. I'm not saying every operator doesn't have a bad day. That does occur from time to time. But our members don't have spare planes sitting around. We can't afford to have spare aircraft or staff stationed remotely just in case. So it is very much a case of a question around the proportionality and making sure that we don't introduce a system that is actually going to create more problems than it's actually intended to fix.
And so would it be fair to say, Mr Walker, that that the association wouldn't be supportive of a push to a mandatory compensation model like we've seen overseas in Europe and Canada?
Senator, I don't think we have quite enough detail yet. I think there could be an argument for that, depending on the circumstances. I think the fact the charter is yet to be settled finally, and the fact that linked to that charter will basically be a set of rules or regulations that we haven't yet seen. So I wouldn't rule it out.
Have you had a chance to be consulted on the charter?
Yes, we have. We've actively participated in consultations with the department, not just on this, but right across the board for a range of other consultations around disability access and other things that they've been dealing with. I think, if I'm to be honest, the consultation has been somewhat challenging for many of us. And I would say that because the level of feedback that we've been provided hasn't been as wholesome as many of us would have expected. We've basically provided our inputs into the system. We've been told that they've been taken on board, but we're yet to sort of see the finality of what that feedback looks like and whether or not the department and those writing the charter are actually taking that on board.
Well, I'm just about to hand back, but I will say the Department of Infrastructure and Transport and Regional Development will be appearing next, so no doubt they've got their ears tuned to that feedback as well. So hopefully they can take that on board as part of today's evidence. So thank you very much, Mr Walker.
Thank you, Senator.
Thank you, Senator Mulholland. I'll throw to Senator the Honourable Richard Colbeck.
Very ornery at this time of the week and previous events. You say that this new system's basically premised on the Canadian system, which just doesn't work. So what direction do we take in the interests of the consumers that we're all concerned about ensuring they receive the service that they've put their hard-earned down on the table for? Yes. In terms of being able to fly where they want to go, when they want to go?
And it's a good question, Senator. I think for me there's two parts to that. The first is that the legislation needs not to be considered in isolation. It actually needs to be attuned or in alignment with other legislation that already exists. As I know you would have heard from, and having read other submissions as well, there's many that believe that the existing legislation mechanisms that are in place for in terms of disability, in terms of consumer protection, in terms of the ACCC, do provide suitable coverage for a lot of these matters in aviation. And I think also, to your point around it is people's hard-earned money, 100%. I think every airline operator, and particularly from an RAAA perspective with our membership, they pride themselves on the businesses they run. Regional aviation businesses and regional airlines are run by people who live in the communities that they service. And everybody gets out of bed every day to go to work in regional aviation and are very mindful of the people that they're serving because they are part of that community as well. So I think it's not so much a balancing act, we need to be well informed and, as I say, the legislation can't be seen in isolation. I think the other final point I'd make on that is around communication. I think with whatever we end up with, for want of a better way of describing it, we need to ensure that the consumer actually understands what's in and what's out. And by that I mean what is a reasonable claim that you have been disadvantaged or you have been badly done by, for want of a better way of describing it, through your aviation experience. Because the Canadian experience, from what I can't give you exact numbers, but from what I understand anecdotally, there are a lot of claims and they are often dismissed because they don't meet the criteria. And as we all know, in some instances, there is not so much an option to do it, but people, when they are frustrated, will look to decision shop, and there are multiple doorways to go in. I'd hope we're not just creating another door for people to go through when there are mechanisms available to them and avenues available to them, but importantly, when this does roll out in some form, everyone, not just the consumer, but all the aviation operators need to appreciate and understand and be well educated about how it's all going to work.
So a couple of points from that. Firstly, if everything's happy and hunky-dory in the kitchen, why are we sitting around the table, would be my first point. And I suspect there's a bit of immediate post-COVID experience that has driven some of that. So I think that's understood. But in terms of your reflections on people understanding what they're entitled to, and the Canadian experience, I think, would probably demonstrate this to a certain extent. Most people just don't care. They've bought a ticket to fly on an aircraft to go somewhere, and they just want to go where they wanted to go when they want to go there. And so all the nuances of stuff that sits underneath it becomes a rather unpleasant voyage of discovery for everybody once you get inside a system. So, you know, I would question the view that the existing toolkit does the job, because otherwise I don't think we'd be sitting here. But making sure people understand is a difficult element when they're probably not all that interested. They've bought a service and they want to receive the service.
So you raise a good point, Senator. I think that is part of the challenge that we all face. Aviation is a complicated and complex ecosystem. As you've heard, there's many moving parts, and I'm not saying the system is by any means perfect. Often it's not one single issue or one single operator's or participants' involvement. It could be multiple. You know, it's the old, situation where it's not just one thing, it's two or three in collectively together have created the problem. I think my comment was more around ensuring that, and I think that's behoved on all of us that are in the system, to make sure that each participant's roles is well understood, but also the consumer is given every opportunity to enjoy the benefit of what they have embarked on doing, and that is spending their money to get from A to B for whatever particular reason it is.
So in the context of the conversation or your submission that talks about And you mentioned it in your opening remarks with an exemption for regional airlines on top of regional airports. How do you carve that element of it out? I live in regional Australia. I'm no different to any other passenger, as you would have seen and heard today. I just want to go where I want to go, when I want to go there. So what parameters would you use, or what thresholds might you use in terms of an exemption for regional aviation if that was to be a path?
No, thank you. As you say, the consideration and the establishment of threshold could be an appropriate way to do that. The government has already signalled doing that for regional airports, as you mentioned, with the passenger movements are 1 million or less. My understanding of that is that pretty well captures the top 14 or 15 airports in Australia, but there's some hundreds of other airports of smaller scale around the country. So the fact that the government is recognising that regional airports are different from major or larger airports is something that we would be politely but firmly asking for, that regional airlines are considered in the same way. In terms of a threshold, I think there's various components that could be considered. It could be a passenger carriage. Most of aviation, for a lot of our experiences, is based on aircraft size and aircraft type. And I would, and as we have posited in our submission, is that a aircraft seat number threshold could be an appropriate way to go. We've suggested 100 seats, which is a fairly large aircraft some would consider. But then the second line of consideration would be around who is operating those aircraft. And what do I mean by that? If a larger airline, be it Qantas, Virgin, Jetstar, is operating a 100-seat aircraft, behind the operation of that aircraft is a fairly sophisticated system that's able to support that, not only in terms of the delivery onto the gate of the airframe itself, fully crewed, fuelled up, ready to go, but it's the back office and it's all the other ancillaries that sit behind it. I have members who operate a handful of 100-seat aircraft, but they don't have the same scale in their operation. If we look at someone like Air North, an example, they have 12 aircraft. Those 12 aircraft are utilised to the best of their ability as much as they can. It's an asset that needs to be worked and needs to generate revenue, but they don't have spare aircraft sitting around. So for ours, it's very much around an aircraft type or seating capacity could be a good starting point to at least have the conversation around what it actually would look like if those exemptions were granted.
So a combination of factors in that sense. I mean, the port where Senator DeLega and I fly to is serviced by 72-seat aircraft operated by Qantas Link, and until some time not too far away in June, 35-seat aircraft operated by Rex. I would get cranky if it was, so it would need to be a structured process with a combination of factors in it to consider those things, given that Qantas Link have the back end that you're talking about and perhaps a bit more scale in terms of aircraft numbers.
Correct. Yeah, so exactly that. It can't be, I suppose, just linear in terms of the aircraft so big, but it also needs to consider the operator and the ability of the operator to, and it's not like people aren't, as I say, members aren't unwilling to do everything they can to support the travelling public. It's more around their ability, be it with having aircraft or staff in their systems to be able to cope with some of the challenges that are presented.
So in that model in your mind, absolutely, where would something like Alliance fit? Where would Rex pre-breakdown, when they're operating the 737s, where would they fit?
I think Alliance is interesting because a lot of their fleet are 100 seats or less.
Yep.
Between the Embraer 190s, the Fokker 100s and the Fokker 70s. Alliance is a little bit more unusual in that a vast majority of their work is FIFO, or it's closed charter, where they are doing that FIFO work in the resource sector. And the contractual arrangements between...
there wouldn't be a consumer per se because it's a contractor.
Correct. Yeah. They're putting it, politely, the employee is travelling. The employer has established the conditions under which they travel, and that's the contractual arrangements in place. And then the contractual arrangement with the airline, in this case Alliance, is very much around the performance measures that they agree to and put in place. I think in the example of Rex is very much similar to a lot of other regional operators. I
get that now, but when they were operating the 737s, it was a different...
I agree entirely. Operating a large aircraft like a 737 on major capital city trunk routes, where you're looking at frequency and volume, is completely separate from a regional community who might receive 2 flights a day and one's in and one's out, and that's it. As I say, it can't be a linear approach. There needs to be some considerations.
Could be size of aircraft, size of operation and destination potentially.
Correct, yep.
Okay.
And I think if you look at those three and there were, I don't like the word carve-outs, but if there was some sort of process embedded within the legislation that the exemptions would be made available, that would be a really strong and appropriate way to protect regional aviation and protect the regional communities that rely on those services.
So Rex's submission was talking about events as classified as controllable. And not necessarily practically controllable, say, crew or maintenance issues in regional operations. How do you think the Charter, as it's structured, distinguish between major carriers and regional carriers in that sense?
I think there's similarities there. I think it would be, justified requirement on any operator to ensure that they are operating in the spirit of, let's say, what the intention of the Charter is, and not necessarily, I don't think any of our members would ever seek to exploit, a perceived loophole or anything like that. The two fundamentals that any operator comes back to, and this is particularly in the regional aviation sector, is the safety matters that I've raised as their primacy. You've just heard from the International Pilots Association around minimum equipment lists. No one is going to compromise the safety or the integrity of the aircraft or the integrity of the flight they're about to embark on. And similarly, the customer experience is front of mind for any operator. Anyone that runs a business is mindful of who their customer are and what their customers' expectations are. And in the regional aviation context, that is very much around providing the service and providing the service to the best of their ability.
So coming to the money question, which is usually the bottom line for everybody, the proposed industry levy structure, how do you suggest that should be apportioned across?
No, thank you for asking the question.
Consumers, I suppose, but also the industry. I mean, some are making this sound as though the airlines are going to pay, but the reality is that the consumer will pay the price at the end of the day. So how should that be best apportioned?
Yeah, no, thank you, Senator. I'm really glad you asked the question, because in terms of the flow-on effects, as one way to describe it, yes, there is a cost to the airline above the line, and ultimately that will get passed through. Every business manages their overheads, and their above-line costs generally go towards the structure of the pricing of the product they're selling, as we know. Our biggest concern is that, yes, there is that downstream impact on the consumer who will end up paying more for a ticket. And we're already seeing that as a worked example right now with fuel prices. We're anticipating fuel prices, whilst availability is good, and the government has done a lot of good work over the last couple of months ensuring supply for aviation and ensuring supply for regional aviation. The cost, the sting in the tail, will be with us for many months to come. I think the key point I'd like to make around the structure or what that scheme actually looks like. The legislation says it's actually a compulsory participation. I think in some documents that I saw early on, and I'm not sure if it's still there, it was described as a membership, effectively. You would be a member of this scheme. And I'm not sure it's a club that all my members would like to be joining.
I'm not sure it's a club that consumers want to join.
Correct. I think I appreciate that it would be mandatory, but then the next question is who's going to pay what. Because you've got X number of aircraft, you're considered big and therefore you pay more, or is it a unilateral baseline fee across the board? Do good operators get put into the same bucket as a bad operator? Does a regional airline who receives very few complaints have to pay as much as a larger operator who might have a few more complaints? I think it's the lack of granularity around that detail that is the most concern. Where there needs to be a landing point, if you excuse the pun, it obviously needs to be settled. But at the moment, we don't have that information to be able to truly make an assessment of that. And when this has been, the issue I've raised as being cost has been raised, the response is generally around, well, that'll be covered off in the subordinate legislation, which is basically the rules and the regs that sit behind it. It would be...
which is the scary bit, because you don't know what's inside the black box.
Correct. The devil's in the detail, as they say. So we would argue that if you are going to charge a cost and require everyone to join the club and have a compulsory membership, that you actually are considered because on the basis of who you are, where you fly, and how good you are at already doing it in terms of past performance.
Would you regard that it would need to be proportionate in some way? And I look at this in the context, for example, of someone who lives in a regional area, regional airport, and looking at a couple of ports in my neck of the woods, one that does require screening, for example, one that doesn't. It's just been assessed as qualifying to go from 3 to 2, and the bill for that's $30 million at a high level early back of the envelope guess, which is big enough on its own. But so that means a significantly higher per passenger cost in that port compared to another port in the region which does this with respect to direct cost of passengers versus what you might get going through Melbourne or Sydney. Yep. So is it going to need to be proportionate in some sense in that, in line with that example?
Yes. Yeah, no, thank you. I'd agree with that. And the security screening is a good example. I think the only there is a difference there, or a point of delineation, in that if we look at security screening, and as you're aware firsthand, if you look at security screening at an airport like Darwin versus security screening at Sydney or Melbourne, the costs are much higher. The challenge with security screening is very much around the fact that that is a regulated requirement that an airline or an airport has very little say in, whereas in the case of this consumer protections, an airline is in a position to influence, and their influence is in their own behaviour and their own performance.
So what sort of stats or numbers do you build into a model that deals with that?
I would think that as you know, data in aviation is quite challenging because it's all lag data, but I think lag data here could be something that we could actually look to access. And by that I mean, I'm sure the major airlines could tell you most days of the week how many complaints they have afoot. And some of my larger regional members would also be able to give you some specifics around the level of complaints they get and what they are about. So I think if you used rather simplistically, used a metric like current performance as a starting point, that could be an appropriate approach.
So, I mean, but that also, I mean, you can cut the data in so many different ways, for example. So you go to cut the data based on Sydney Airport, where you've got a certain number of movements per hour legislated in 15-minute modules, and if you miss all the slots in the first 15, you can't make it up in the second. You know, so you've got those sorts of overlays. Western Sydney, when that comes online, which is open skies, and some of the others that are less restricted. How do you build something that takes into account things which I think the airlines reasonably say weren't my fault, or not enough air traffic controllers turned up to allow the airport to operate even? Yep. I mean, how do you build that into the system, and how do those that are effectively responsible for what's gone pear-shaped take their chunk of responsibility, and then we throw the big fella upstairs in and his big weather balloon, and who knows where that takes us?
I think in answer to that, I'd say we need to, it comes almost full circle back to the actual legislation itself and the charter that eventually results from it, and that is around actually clearly delineating what some of those causal effects are, and who is the owner of that effect. In aviation, weather is one of the most variable and challenging areas, as you quite rightly point out. In our submission and our position has always been that it shouldn't be a select few. Everyone that's part of that ecosystem or contributes to the ecosystem needs to be responsible for their piece of it. And Air Services Australia, for a traffic control perspective, they do actually capture data that reflects how much time they contribute to in terms of ground delay and airborne delay. I think there are other key government agencies, be it Border Force in terms of securing the borders, and also the immigration component of as well. They're currently excluded from this. I think we need to actually understand who all the participants are, which parts they contribute to, and then that will inform, I suppose, the validity of a complaint going forward, and whether and what level of compensation should be attached to it.
Thanks, Chair.
Thank you. You're up.
I'm cool.
And I think Senator Mulholland, thank you very much for your time. I don't think you've taken any questions on notice, but if you do, they are be returned by a date that I'm looking for very quickly. Monday the 8th of June. Thank you very much.
Lovely. Thank you, Senators. Appreciate your time. Thank you.
Oh, there we go. I've got one here. Rightio. We'll now welcome representatives from Department of Infrastructure, Transport, Regional Development, Communication, Sports and Arts, and Ms Lauren White from the Australian Competition and Consumer Commission will join us via video conference. Hello? You're not well. Yeah. You want? Yeah. Okay. I understand that information on parliamentary privilege and protection of witnesses giving evidence to Senate committees has been provided to you for the amount of time you spent in the building this week. I imagine you're quite used to it. I remind senators that the Senate has resolved that an officer of the Department of the Commonwealth of State shall not be asked to give opinions on matters of policy and shall be given reasonable opportunity to refer questions asked of the officer to superior officers or to a minister. The resolution does not preclude questions asking for explanations of policies or factual questions about when and how policies were adopted. For the Hansard record, I'll go in the room. Will you please state your full names and capacity in which you appear today, starting with Ms Parry.
Thank you, Senator. Rachel Perry, Deputy Secretary, the Transport Group, Department of Infrastructure.
Good afternoon, Samantha Palmer, Interim Aviation Consumer Ombudsperson.
Jennifer Stace, First Assistant Secretary, Domestic Aviation Reform.
Ben Ma, Assistant Secretary, Aviation Consumer Protections.
Right here. And Ms White, are you online? We see you logged on, but I'm hoping you're there. Yes. You're there?
I am. My apologies. I'm having some technical issues. Lauren White, Acting Executive General Manager, ACCC Consumer and Fair Trading Division.
Thank you very much. Oh, there you are. I'll now ask if the department has an opening statement.
Not an opening statement, Senator, but we would just like the opportunity to put on the record today just some factual corrections from things that we might have heard earlier during the day.
We'll do that straight after we sing.
Sure.
Does ACCC have an opening statement?
No, thank you, Chair.
Well, Ms Parry.
Great.
Corrections.
Thank you, Senator.
Thank you. So in respect to the airlines evidence earlier, I'd just like to correct a couple of points with respect to the current proposed charter. The proposed charter reflects feedback and we have received, and it currently notes that marketing airlines are only responsible to comply with the information obligations in the charter when selling flights, and that only operating airlines are required to meet the operational requirements for the flights that they undertake. The second thing we're keen to correct is, having heard the feedback about different catering options in different locations, the proposed obligations now reflect flexibility for airlines to provide reasonable food and drink using mechanisms that are appropriate to where the disruption actually occurs. So the definition of disruption was also increased from 1 hour to 2 hours for domestic flights and over 4 hours for international flights, which practically means any airline could provide bottled water or prepackaged foods, for instance, where cafes are not available at that location. And then lastly, there was a lot of discussion about things outside airlines' control. There are clear definitions in the obligations that reflect airline feedback, which identified causes outside their control. These explicitly include airport infrastructure failures like baggage belts and aero bridges, decisions by security authorities like evacuating an airport that might cause a delay, and air traffic control decisions or staffing matters that may result in delays. So the current proposals do not require airlines to provide care or support to affected passengers as a result of these issues, nor provide refunds in these cases. So they're not on the hook for those things in these cases. The other thing there is that no air passenger protection schemes in the world that we are aware of include entities outside of airlines within their schemes. While some do require airlines to provide care and support and refunds in cases like the ones I just mentioned, the current proposal in Australia does not.
Yes, thank you very much. In the interest of both supporting Senator Mackenzie, who was ill today and has risen to come to this, and getting her out of here so we don't catch it, I would invite you to go first. Senator Mackenzie.
Thank you, and just thank you. The reason we're actually here today is because of the poor performance of the aviation duopoly over time. Qantas and Virgin holding 98.8% of our aviation sector. We've seen a step change in cancellations and delays post-COVID, which continues today. Pre-COVID, the long-term average delayed flights was 17.8%, with a 1.5% of flights cancelled. In 2025, way post-COVID, 1 in 4 flights were cancelled and delayed, with 2.5% cancelled. 3.2% of Qantas flights were cancelled. And given this is a problem of the major airlines making, that we're actually here today, why has the government decided to expand the coverage of the scheme to all airlines whose cancellation and delay data are minnow in comparison to where the real problem in our system is? Can you answer why you've expanded it to the smaller airlines, when 98.8% of the problem lies elsewhere?
So I might start, Senator, and then I'll pass to my colleagues. So I think, in essence, the framework for establishing this legislation, as you know, goes back to the Aviation White Paper. As you've identified, these are problems that go back some time. I think the government has made a commitment that it wants to establish these consumer protection for all travellers, irrespective whether they're travelling on smaller airlines or larger airlines. They want to establish a baseline for consumer protection across a variety of sectors. But
well, Ms. Parry, I'm not sure whether you were around at the time, but this did arise from the opposition at the time, putting their own private senators' billing around pay on delay, given the tsunami of public anger, not political pressure from the opposition, but we held an inquiry into the behaviour of Qantas, particularly around increasing competition on international flights. And as a result of that, senators were swamped with thousands of everyday Australians raising issues of COVID flight credits not being repaid. And I know we've heard evidence in this committee today about Virgin dropping the ball on that. And so would also like to call that out. That's not kosher, and this issue as well. So, again, you're using a sledgehammer to squash all instead of actually, once again, allowing the problem, which is the big boys in town, getting away with it.
So I might ask my colleagues just to expand on that a little bit in terms of some of the other airlines that are covered, some of the smaller players that are covered.
Well, then I'll put my second question in as well, if you're going into the detail around how much are small regional airlines expected to pay under this scheme?
Senator, I think you raised a number of questions there, but we might just go back in time a little bit before your reference to the pay on delay bill. As you would be aware, or are likely aware, the 2009 Aviation White Paper identified aviation consumer protection concerns, which gave rise to the creation of the industry-operated Aviation Consumer Advocate in 2012. That was ineffective. And the 2024 Aviation White Paper, the strong feedback from consumers, as has been heard today from other witnesses, was that the current arrangements are not working. I'm not aware at any point in time where it's been proposed that a industry-based protection framework would only apply to certain entities. I'm not aware of a parallel within other sectors. We've been looking at international models and domestic models. They are all
all-encompassing, irrespective of
industry-wide. Senator.
So how much will small regional airlines be expected to pay under Labor's scheme?
So, Senator, going to costs, there are two distinct aspects. There is the, within the bill framework, there is the levy that will be payable by industry to fund the administration costs of the regulatory function to enforce and monitor the standards proposed in the Charter.
So how much is that?
Well, Senator, that will be subject to further consultations through subordinate legislation. However, based on internal indicative modelling, we'd be looking at less than 5 cents per passenger for an airline. And then the other...
Is that based on current seat capacity? How will it be applied? You've obviously had to model this to get it through ERC on the current data. So how have you calculated that?
So looking
per flight or yeah.
RPT, Senator, so regular passenger transport volumes, passenger movements effectively. That's consistent with our other regulatory schemes that look at market share and looking at the entities we are looking at regulating under this framework. That's the best measure.
And I'll just add, before, like as Mr. Marr mentioned, there's still consultation still to happen on the levies that would be applied, and it would be consistent with the government's charging framework. So we would develop cost recovery implementation statement as a part of that process, which would, support that consultation process and explain why the fees would be set the way that's proposed.
But you are exempting Air Services Australia.
Senator, I'm not sure I would characterise it that way. Again, looking at international frameworks, I'm not aware of any international framework that regulates an air traffic controller. This framework is based...
Mr Maher, you will have watched this committee's Senate estimates over the last decade, probably 2 decades, and seen the underperformance of our air traffic service provider, leading to the resignation of a guy that was, on a remuneration of over $1 million and could not get the organisation to function in a way that allowed planes to take off and land in time, to the point that our own airlines, instead of being one team, one dream in the sky as they had been with Air Services Australia historically, started to differentiate when telling passengers what the cause of the delay was. They were very happy when it was to take responsibility when it was their problem, but when it was Air Service Australia, they were happy to let consumers know. So I hear you, I see you, Mr Maher, but I would argue, and I think the evidence would show, that a lot of the cancellations and delays that are experienced in our aviation service sector are as a result of Air Services Australia, and I think this would be a wonderful way to give them a little carrot.
Air Services is
Hands up, they laughed.
Is already regulated, and they don't have that direct customer relationship which the airlines have with the passengers. But
they're still responsible. So this is the problem.
Yeah.
I get the consumer-facing piece, but I think you could get no better pressure point than for a company like an organisation like Air Services Australia, that if they cannot get their rostering right, which is literally what's happened, and we're cancelling people's not just their holidays, work trips, etc., the drag, the productivity drag, the consumer cost, it is their responsibility, and therefore they should pay. This is where those that caused the issue should be responsible for the commensurate compensation. That's what I would be arguing. And I would suggest that the strong view of the opposition would be the same.
On that same point, when I'm reading what I think is the latest update to the charter release, is that this morning?
Sorry, I'm not sure what one you're referring to.
Looks like a document looks like this. This officials mentioning all the things it actually says. The tarmac delay, except for remaining on board necessary for immediate safety, security or air traffic control reasons. So that is the language I'm reading. Does that mean a consumer has no recourse at anyone if it's stopped for air traffic control reasons?
No, they don't.
It's not been contemplated through the consumer protections that this legislation covers, Senator.
Yes.
So it's not part of the current legislative framework. As Ms Stace was saying, Air Services is covered under other either regulatory and expectations set by the minister, but because of the consumer-facing nature of these protections, it is focused on the airlines and to a lesser degree the airports.
Suffering the same delay, just for a different reason, we've created a different subclass of passenger.
That's the point. Exactly.
It's consistent as well with the comments made earlier around safety being a priority. So it's along the same kind of operational considerations.
No, if there's a storm and we can't take off, everyone that's not Air Services' fault. I still believe in acts of God. Sorry.
Testify.
But I testify. Amen. Sorry, don't. So, Mr Maher and I we do this. We have done this previously, and I will take you up and correct you because the Minister has said she is excluding small airports under 1 million passengers will be exempted by ministerial determination. And so there is grades of application of this particular regime. So I would be asking if we are exempting small regional airports of under 1 million passengers. They're similarly, for the 1.2% of flights that Qantas and Virgin aren't running, that aren't being cancelled and delayed, there might be an opportunity to look at carving that out as well. Now, we're not just setting up one regulator, are we?
No, Senator.
How many?
So, Senator, if we can just go back to the principal aspects of the bill. So, as I said before, there is the creation of the charter that will set standards that airlines and airports will be accountable for. I would say the correct characterisation is a regulatory function. There is not the creation of a new entity. That regulatory function would be within the department in the same way that we regulate airports, airport construction. The bill itself doesn't refer to a regulator. It provides regulatory functions that sit with the Minister and the Secretary. And then finally, there is the creation of a dispute resolution scheme that will be administered by a company independent of government, comprised of industry members.
Okay, so as I understand it, we've got a new statutory Aviation Consumer Protection Authority regulator.
No, Senator.
Based in the department.
Regulatory functions.
So it says authority in its title.
It's a name, but it's a regulatory function that would sit within the department. So it's not a separate entity, if that makes sense.
Right. But it's not a statutory entity?
Well, no, it's not, Senator. It has statutory duties, regulatory duties under statute, but it is not an entity. It is providing regulatory duties and responsibilities to the Minister.
And how will that be funded? How much are we expecting that to cost?
I'd have to bring up the budget papers.
That would be great,
Senator.
Yeah, they should be in your back pocket.
But I can tell you offhand, it's in the order of 4.8 million per year, Senator.
4.8 million for the Aviation Consumer Protection Authority, which isn't an authority.
For the functions, for those functions, yes, Senator. I acknowledge that the terminology is confusing.
And will that cost be recouped through
I can help you, I think, Senator.
Yes, cost recovery.
That goes to my earlier statement, that total quantum of 4.8 million divided by the number of entities that are to be regulated and the passenger movements that I referred to before comes to about 5 cents, depending on how the model is applied, per airline, per movement.
Right. Yep. And over the forwards, does the 4.8 change?
It does slightly, Senator.
Let's go over those ones.
Okay. Fortunately, I have my Senate estimates pack here.
You found your budget papers.
He's one I prepared a little earlier.
This isn't our first radio, Mr. Maher and I.
It is. I think it's slightly lower in the first year. It just sort of totals up. So it's about 4.8 a year.
Is the 4.8 the slightly lower year?
In the first year, yeah.
Yes.
Yeah,
and
we've allowed.
So that's what 20. Can you just
in 26, 27?
Okay,
obviously,
what's 27, 28?
Timing for the scheme would depend on when things commence. So I think that we've allowed 4.8 million a year.
Yes, and 27, 28?
Yeah, 4.8 million.
Yep, and 28, 29?
4.8. So it's a 4.8.
So you're not anticipating more people to be flying over the next 4 years, or more flights, or a static environment?
So the functions for the regulator effectively enforce the charter. So it's not on a per complaint handling or
No, I get it.
Growth
I get it.
Yeah.
But as I understood it, was per passenger is in the denominator of this.
That's to give an example
for the cost
of
recovery.
What that rate would look like played through. Yeah, so it's not being tapered up as you're correct, as the sector grows over time. We haven't.
So that's pretty sad that you don't think the sector's going to grow over time. I'm sure the airlines would be hoping the opposite.
Well, this is a forecast. Obviously, as we've said, the levy arrangements will still be subject to further consultation and a cost recovery process. As I mentioned before, we will do a cost recovery impact statement, that would be part of determining what the levy would be, and if that process factors in that growth rate, then those amounts would reflect that in the budget going forward. And that process would be an annual process, like any sort of charging arrangement that government would set, which would allow for that to,
and how many
respond over time.
How many staff in the new statutory Aviation Consumer Protection Authority regulator based in the department?
In the order of 16 ASL,
16?
Senator.
Okay, let's go to the new statutory Aircraft Noise Ombudsman, which isn't a separate regulator, apparently located in the department.
That's right.
Correct, Senator. Again, they're regulatory functions.
Okay.
That
how
would
much over the forwards and how many people?
So, Senator, in terms of money, in 26-27, there is $1.32 million.
Yep.
In 27-28, there is 1.218, if you want precision, Senator.
I would appreciate it in this instance.
In 28-29, there is 1.189, Senator. And then in 29-30, there is 1.19.
And how many people?
In terms of people, Senator, 4.5 ASL across each year.
Okay, thank you. Any SES at all? And any SES in the 16?
Within the 16, Senator, there is one SES. And within the 4.5, that includes 0.5 of an SES. Both band 1, Senator.
And does that include, sorry, Ms Palmer, you are the Ombudsman?
Just in the interim in the department.
Okay. And are you included, is your role included in the 4.5?
No.
Okay, so we also have an Ombudsman in the Ombudsman, Aircraft Noise Ombudsman. Okay. So this is for the new statutory Aircraft Noise Ombudsman that doesn't include the Ombudsman themselves.
Senator, just to clarify, I recognise again it's confusing.
It's not confusing.
Well, I think it is. We have two separate.
And I wonder whether that's all.
We have two separate ombuds functions.
Yes.
So, going to the first one that you're referring to, there is currently an aircraft noise ombudsman that operates within Air Services. The bill and the government's commitment in the white paper was to legislate that function. It is not currently legislated, and to make it independent of Air Services as a body that it reviews. That's what the bill does. It creates that function with an SES departmental officer performing the functions of the aircraft noise ombudsperson. Is that clear, Senator?
Yes, and do they have staff to support them?
So there are 4.5
so that's the ASL
performing those functions, including the SES officer.
Well, how much is the Ombudsman paid?
How much, sorry?
Is the Ombudsman paid? Because I've got the forwards for the four.
So the aviation noise ombudsperson would be paid at normal SES band 1 rates, Senator.
And what is that?
I would have to take that on notice. It's
really?
It's in the order of $250,000, Senator.
The ranges appear in our annual report, Senator. We can dig those up.
I just don't know. Yep. So we've got the aircraft noise ombudsman located in the department.
Yes, Senator.
And then we've got a legislated aircraft noise.
So going to the second, so that we've got the aircraft noise ombudsperson as an SES officer, 0.5 of an SES officer within the department, and then separately another entity, we have the Aviation Consumer Ombuds Corporation, I would say. It's quite confusing.
I'm getting to that. The new Aviation Consumer Ombudsperson Company.
Yes, so it is not a ministerial appointment of a person to be an ombudsperson.
You didn't get Utopia to help you out with this one, did you?
It is consistent. I, again, acknowledge the terminology is confusing. It is consistent with the terminology used, for example, in the telecommunications industry. We have a body called the Telecommunications Industry Ombudsman. That is actually a corporation in the same...
So what... Okay.
Yeah.
So when are we... So the legislation this legislation will take that function out of Air Services Australia and put it...
The noise function.
Only the noise.
It's a function that currently exists that is transferring to the department in the interests
and now the company, the Aviation Consumer Ombudsman Company, it isn't in the department?
No, it's not.
No.
Is it independent of government?
Yes.
How so?
We have been through various governance models, Senator, throughout the journey since the 2024 Aviation White Paper commitment, where the government landed reflects strong feedback from consumers, consumer groups, lawyers and industry, that function should be independent of government. It was recommended by choice by ACCC, is consistent with Treasury's benchmarks for alternative dispute resolution, which is to have a standalone company, not-for-profit company, comprised of industry members, so they are compelled to join that scheme by statute, but the decisions are made by independent employees.
Not only compelled to pay, they're compelled to play with each other as well.
Well, yes, Senator. That's
sorry. Okay. Got it. How much is it going to cost to run this?
So that would be a company independent of government, Senator. So the structure consistent with, for example, the Australian Financial Consumer Authority, the AFCA, and the TIO, is that it is the industry members, the company that sets the fees, and the participation of industry members incentivises them to keep costs low. But how that company operates is subject to rules approved by the government.
So there is no impact on the federal budget?
We are, sorry, just to clarify that, not in terms of operating, but the budget has provided some interim money to help set things up and do some transition to get it running. So there is some funding for that purpose. How much will it cost to set this up? And you're anticipating this to be an industry owned and run and funded company?
Yes, Senator. So in respect of supporting the standing up of the company in that scheme, the budget provides for $3.739 million only in 26-27 as a transitional arrangement to support the standing up.
And so what's that going to do?
So that will fund a collaboration with industry to establish the new entity. So, for example...
Who are you paying the $3.79 million?
Well, that is departmental funding, Senator, and we will work with staff internally and with consultants. So, for example, there will be the requirement to draft a constitution for the company, rules as to how complaint systems work. What else have we got? Sam, have you got?
To set up a business case for the complaints management system so that can get going very quickly to support the early implementation of the scheme, as well as engaging with the members of industry to support them to get that company up and running as quickly as possible.
So the independent industry-run body is going to have its constitution drafted by government?
Government would play a strong role in that, and the minister must approve that. And there are requirements in the bill that go to how that company operates, including, for example, Senator, that there must be equal representation from consumer and industry perspectives in terms of board composition.
So, given you're taking the current aircraft noise ombuds role out of Air Services Australia and legislating it into something else, will we see a commensurate drop in Air Services Australia fees and charges?
The function that Air Services currently operate reports to the Air Services Board, so it doesn't really sit within the entity of Air Services as part of its sort of day-to-day operations.
Who funds it?
It has been funded to date, sort of Air Services absorbing that cost with some contribution provided by the Department of Defence.
When we say absorbing cost, it sounds like it's carefree, like I've just absorbed it, like It really didn't cost. No,
That's
it
right.
costs.
So it hasn't
It just
been
means their balance sheet
specifically.
looks worse.
It's not a function that's been specifically funded for air services to run. So in setting it up under the legislation and providing that as a prescribed arrangement, the government has provided in the budget some funding for that function.
Is the running of this aircraft noise ombuds within Air Services Australia funded independently by the department, funded by industry, or is it run and paid for? Who pays for it currently?
It would currently be paid for by Air Services,
Right.
with some funding also provided by Department of Defence.
Excellent. Yes, of course, because there are those shared
Mhm.
spaces. So my question then, given it is funded, they have got there in the end, by Air Services Australia, out of their balance sheet, will we then see a commensurate drop in fees and charges by Air Services Australia to those that are currently subject?
As I said, it's not a function that's ever been funded directly, so I would consider it more like a terminating measure in that sense. So you would see that Air Services no longer has to pay for that function.
Yes.
The government has provided for that function to be paid for by the department. So it's more like that function will, is it like a terminating measure? More
No,
like
it's
that.
not a terminating
Well, it's
measure.
not it's not an
because
actual terminating measure, but-
the role still exists elsewhere. It's being funded in another way. That means who was currently charging for it doesn't have to pay for it anymore. So you know what people like to see? If you're not having to pay for it, don't charge me for it.
So,
don't
Senator,
charge me for it.
I would describe it more as a cost pressure that will no longer exist within Air Services because the government has funded.
Yes,
that
sorry.
position at that amount.
Why hasn't there been a regulatory impact assessment done?
So, Senator, we've been consulting with the Office of Impact Analysis as the responsible agency throughout this process. Their advice has been that the appropriate vehicle for finalising that assessment is when the charter is finalised, as that will contain the detail.
So this seems to be quite an endemic practice within this government, that we are getting bills to Parliament without risk assessment. Did the Minister's office request that a RIS be done?
Senator, the normal order of events is that we consult with the Office of Impact Analysis as part of the Cabinet process.
So the Minister didn't
occurred.
say, why isn't there a RIS with this as well?
Chair, Senator, we're on hard 3 finish and I have to rotate.
Yeah, sure. Thank you. Just on notice, I'll read my notice. What the public purpose of having 2 separate regulators undertaking inquiries and advocacy and public education campaign, and how much of this duplication will actually cost Australian travellers on notice. Thank you.
We'll take those questions on notice. And just on that last point, Senator, the Minister understood that the RIS process would be happening following the introduction of the bill and through our consultation process.
Thank you, Chair. I've got a few questions just to ask, and we want the opposition to have as much time as possible to get your questions through. Just for, I don't know, Mr. Mayor or Ms. Perry, if you're able to ask this one about the view that was formed by government. Did the government view that many consumers primarily want timely assistance, certainty and communication during disruptions, rather than purely financial assistance after the fact?
So can you just repeat the question one more time for me?
Sure. So did the government form the view that many consumers primarily want timely assistance, certainty from communication during disruptions, rather than purely financial compensation after the facts?
Got it. Thank you.
Senator, we do have significant evidence, thanks to our first air traveller survey, around the core issues that consumers are really seeking improvements in: information and being clear about fees and charges prior to booking so they can make an informed decision; support where required, particularly for vulnerable consumers during check-in and boarding; very clear definitions and support around care and assistance; refunds, rebooking when there are significant delays and cancellations or denial of boarding. It's the area of the most significant complaint that comes through from consumers and causes significant frustration. They're particularly also very concerned about the level of customer service support and complaints assistance. And our complaints review found that for industry, there is basically a focus on customer service in relation to the revenue a consumer can generate, as opposed to rights and fairness and entitlements when seeking to try to raise and escalate issues for resolution. So those matters are the core matters in the Charter that respond to the issues that consumers have been raising over some time.
So flexibility and adaptability was a key consideration as part of that?
It is in how we are currently proposing to draft the obligations, recognising that there are a range of entities that are regulated and they operate in a range of destinations and circumstances. So listening to feedback and ensuring that minimum standards for consumers are clear, but also that we're not creating unnecessary cost or burden in how those can be applied, with detail and case studies and information to support regulated entities yet to be worked through once we've finalised the proposals for government consideration and roll them through.
Thank you. And I know in some of the submissions that the committee has received, there have been concerns raised around delegated legislation. Can you walk us through some of the advantages that the government sees in implementing detailed operational standards through consultation and legislative instruments?
I might cover this at a high level, Senator, but I would say that the way the bill has been drafted in terms of what's in the bill and what's in delegated legislation reflects modern drafting standards and is the same, excuse me, the same approach that has been taken in.
Thank you. You're right, mate. You've just been through a bit of a grilling, mate, so take your time.
Oh, no, that was fine. No, that was fine. Incomparable frameworks, and so I previously referred to the TIO and the AFCA, and to correct a explained acronym, it's the Australian Financial Complaints rather than Consumer Authority. Having that detail, and you've heard quite a lot of evidence today around different views on the detail that should be in the Charter standards, allows the Charter to be responsive to changes in industry practices and consumer expectations throughout the course of drafting the Charter standards. For example, there was an initial proposal to require physical signage at the time of booking, and we got quite strong feedback that that's not plausible in all scenarios, particularly with some airports moving to electronic signage only. So that's an example of where useful to have that flexibility to put that detail in subordinate legislation.
So that's where I guess we're going to. Am I correct in saying that the standards, as they evolve over time, we can be flexible and adapt to the times and feedback with using the delegated legislation model? Absolutely. And when you look at international parallels, Senator, for example, I think all of the examples I can think of all put this detail of obligations in delegated legislation. Canada, they've had their framework in place for, I think, a decade or more 2019, and they've already been through a review and updated that detail in subordinate legislation.
About to update it.
Or about to, in the process
they
of.
They consulted very clearly and they're about to.
And Senator McKenzie was asking you about the costings in the budget papers, and you mentioned the $4.8 million per year. If there was a pay-on-delay bill that got up, would that require a larger regulatory function to be created than what is being proposed currently?
Well, that would be a hypothetical, Senator, but I would say, based on international experience and Canada's experience in particular, there was a very high degree and unexpected degree of cost associated with administering a compensation-based scheme. Their advice to us has been there is a consumer incentive to lodge a complaint to seek compensation even where the consumer may know or reasonably believe that they are not entitled, because they see a potential financial benefit from making a complaint and having the possibility of receiving compensation.
I think the other thing that has been learned from international experience is that the pay on delay doesn't necessarily lead to any increased performance. So potentially increased costs, but not necessarily better outcomes for consumers.
Thank you for that. And I just have a couple of quick questions for the ACCC. If you're there, Ms. White, thank you very much. And just following on from a couple of questions that were asked around Qantas and Jetstar and Virgin earlier on, how should, in your view, how do you see consumers, how they should understand the interaction between airline descriptions such as non-refundable fares and their underwriting rights under consumer law?
Yes, so, and this is a constant challenge, but the way we see it and the way we want consumers to understand it is that their rights under the Australian consumer law are absolutely fundamental. No airline policy can detract from what they're entitled to under the Australian consumer law. However, there is a range of circumstances that are not captured in the Australian consumer law that consumers will need to have regard to policies in relation to.
And where the airline offers travel credits following major disruptions, how should consumer law principles inform whether a refund may also be required? I don't know if you heard, for example, Virgin have got $90 million in a bank, probably accruing a nice little bit of interest that is owed to their customers. How do you see that inform whether the refund should be required?
Yeah, sure. So this is quite clearly set out in the consumer law that in the event of a major failure, which would be a cancellation or a major delay, the consumer is entitled to a refund or a replacement. And so that is a refund. That can't be a travel credit. However, that is circumstance dependent. So it depends on what caused the cancellation. There are some types of cancellations that won't enact that consumer guarantee right, but there are others that will. And obviously Jetstar, they operate on that travel credit type basis. Do you see that that's within how are you looking at consumers making sure that they are protected and they are not just being offered a credit when they should get a refund? So we watch our reports closely and actively encourage consumers to report to us. We provide education so consumers know how to enliven their own consumer guarantee rights, but ultimately it will be fact dependent, so it's not always that easy to assess whether there's a general blanket approach that's problematic or not. Well, I guess I'll just put it to you. Do you consider the Jetstar's refund and travel credit policies to be compliant with the ACL at the moment? I have not looked at them closely in preparation, but I will do so. If you could, that would be great. I'm happy to pass back to the opposition. Thank you.
Call back.
I'm just trying to put together all the various costs that sit here, and I don't think by the time Senator McKenzie finished her time, we'd actually got to all of that. So at the moment, we're talking about the departmental functions of the Aviation Protection Office running at about $4.8 million. Is that right?
That's right, Senator. That's the estimated cost over the forwards right now that is in the budget papers. Per annum. That's right.
Per annum, yes. And then you've got about 1.2, 1.3 per annum over the forwards for the Aircraft Noise Office.
That would be funded. That's been funded directly by the government. That's not anticipated to be part of the levy.
Okay, so directly appropriated. That's right. That's an appropriated cost. And then you've got the company, which is receiving 3.8 just under for establishment.
No, Senator. That money is appropriation to the department to support the standing up of a company.
So where do the costs for running the company come from?
The company, Senator.
And what are they anticipated to be?
The company doesn't exist yet, Senator.
No, but we're talking about developing a process and understanding how much things are going to cost and how much effectively consumers, travellers, are going to pay. How much are they going to pay for the company?
So the legislation, the bill before Parliament, prohibits the charging of complaint fees to consumers.
Yeah, but that's the biggest I mean, if you're imposing a cost on the company, right, and this will be an overhead cost, you're telling me that they're prohibited from passing that cost through their business to charge a consumer?
No, Senator. What I'm saying is the bill prevents the charging per complaint on a complaint basis through to the consumer.
I actually never said they would be. I'm trying to work out how much this is going to cost the aviation system. That's what I'm interested in. And then so how much is this body, the company, going to cost the aviation system?
So that, I think, Senator, I think I can help you out there. That will be subject to consultation as we go through the process of establishing the Ombuds function. The governance function of the ACO, it will be, as Mr. Mara has said, funded by fees from the regulated entities. That allows industry directly to influence the fees and the operational costs because they are obviously a part of the company. So their incentive will be to keep those costs as low as possible. But the final determined costs, the final cost to consumers, the final cost of the company have not yet been determined, and that's subject to the consultation process we're going through now.
So we have no idea what that's going to cost. I mean, surely someone's done some sort of estimate of what that's going to cost.
We have done some work as part of our complaints review to identify what types of roles and setup is required and looked at other ombuds functions. But again, it depends on the scale and scope and also the eligibility of what the scheme needs to undertake. You can look at other ombuds schemes and the relative size, and it depends quite often on the staffing in relation to the number of complaints that are expected to be received. So there's more work to be done.
So what are we comparing it to?
So we've looked at other existing ombud schemes, the water and energy ombud schemes that are run by state departments. We've looked at internal ombud schemes that operate currently in the Commonwealth, like the student ombudsperson. We've looked at the telecommunications ombudsman and AFCA. They're very different models because they have a very much larger number of entities or businesses, and they have a lot more numbers of complaints in that context. So we're still working through what the numbers would be.
But surely there's some sense of what this is going. I mean, there's got to be some idea of what we're.
It's other people's money. Don't worry about it.
I mean, seriously. Well, that's my problem. I mean, someone has to pay for this. It's not going to be appropriated, and I'm betting that's the case. Jim Chalmers is not going to pay for it. It'll be paid for by airline consumers. You've said to us, oh, it's only going to cost less than 5 cents a passenger. Well, we know it's not that. Is it another 5 cents a passenger? Or is it $1 a passenger?
I think it's worth recognising that currently consumers pay the cost. They do not have a mechanism, and that is what they have told the government very strongly.
But I'm trying to understand what the cost of the structure you're looking to set up. That's my job.
Senator, I think what we're trying to explain to you is that those costs are going to be determined through an industry-led body, and that is subject to the consultation process. Once the subordinate legislation has been consulted on and finalised, then those final costs will be determined.
So is there a comparative body that I could look at that has a cost of, I don't know, $10 million a year to run, $30 million a year to run? Is there a comparative ombuds office somewhere that I could look at and say, this is going to be comparative to that? You've made the comparisons. You've said, Ms Palmer, that you've had a look at that. What are we talking about here?
So the aviation industry is quite different in the context of at currently very low levels of people complaining because they perceive quite very difficult barriers, and they don't perceive any benefit in complaining in a number of channels.
Yeah,
and
but we're
so
going to create them something
to do
that. Don't we? Must anticipate something that's going to be some level of activity.
Yes.
We already, there are people who complain.
So, Senator, I think, again, you've heard the comparisons that we have been examining, you've heard the process that we're going through, and you've heard our testimony today that says we don't have a definitive dollar figure that we can put on that function. That is the subject of ongoing consultation, and that's the subject of the final configuration of the Aviation Consumer Ombuds scheme. And that will be
so
funded
you've looked
by
at
the
other
industry
organisations and you don't know whether this might align with that one, that one, that one or that one?
Senator, I think it's fair to say that the cost will depend on the final standards and obligations that are set and the consumer response to that. So both of those are two very significant variables. For example, when we looked at Canada, they had a very, very high degree. They underestimated how many complaints they were going to get because of the incentive that compensation provided. So we can't really make accurate forecasts at this point until the detail of the obligations
Your
is set.
answer just frightens me even more.
And that will be subject to a future consultation.
Because they didn't anticipate what they were going to get. I mean, we don't know whether we're going to have a bucket, a barrel or a reservoir.
So I think Mr Mayor's comment, though, was in relation to the compensation element of the pay on delay, which is not a feature of this legislation. That's what was driving those numbers in the Canadian example, one of the reasons why the government wanted to stay away from it in the Australian context.
And one of the obligations within the proposed charter is to improve the way in which the industry actually engage, provide service and handle complaints, which the complaint review found was not meeting the Australian standard. If, in fact, consumers can engage more accessibly with airlines and airports in relation to their matters, then if those can be resolved at the first hurdle, then there will be a lot fewer complaints likely to go through to the Ombuds scheme.
It's an escalation model.
Yes.
So to the ACCC, how does this scheme fit in within or align with existing consumer protections? We heard Professor Samuel earlier saying he believes it should fit within the functions that the ACCC currently undertake. How does what's being proposed here align but with your functions? Although, given the last range of answers, I'm not sure that you can answer the question because we don't know what it is we're talking about until we get the documentation finalised.
Well, what I can say generally is we can't enforce individuals' consumer guarantee rights. That's not actually available to us under the Australian Consumer Guarantee Law at the moment. And so we see time and again consumers reporting to us that they cannot access effective, timely dispute resolution, and that's not something that we can do. So whilst we will take on systemic issues around representations around consumer guarantee rights, in terms of the day-to-day getting customers what they are entitled to, we very much support a complementary scheme that can facilitate that.
So consumers have, under the current rules that you operate, consumers have refund rights which don't apply to the airline industry. Does this give them that?
So sorry, they do have refund rights as it relates to the airline industry, but they have a private right of action. We cannot take action on their behalf in relation to their enforcing their individual consumer guarantee rights.
At 3:05, we will have to say that concludes the hearing for today. Thank you to all witnesses. Thank you to Hansard Broadcasting. Thank you to the Secretariat. And thank you for Link for delaying my flight so I could stay till the end.